well. All right, so I do need to take a couple of cases out of turn based on medical reasons and or charges. That being said, I also need to take cases out of turn because I have attorneys here who need to be in other courtrooms. I do that as a courtesy so that they can be in other courtrooms because I have attorneys who are permanently assigned to my courtroom versus attorneys who are not permanently assigned to my courtroom. I'm doing it as a courtesy. Please do not think I'm doing it for any other reason. I'm not going to touch out of county holds, out of state holds, violations of probations on signed warrants, or KPSs for the most part. Please note that these proceedings are not only recorded, but live streamed on YouTube. That being said, that is why the interruptions need to be a minimum. If you interrupt these court proceedings, whether in person or by Zoom bombing, you could be ejected from these proceedings without warning. Let's start with our out of turns at main jail. They asked that we take somebody, actually, we don't have Spanish interpreters now, so let's go over to Conti facility. Is Conti not up? Okay. Oh, there we are. All right. So who's the first person that we have here at Conti?
Pastor Hernandez.
All right. So this is Mr. Hernandez on page 25 of the regular docket. All right. It looks like it's a change of charge. Mr. Linder, I'll turn to you first. I do find probable cause for harassed victim and witness informant in second-degree felony case of firearm by felon. First, you, sir.
One moment now. Some copy.
For which,
Your Honor.
yes,
Yeah.
sir.
On the firearm offense, I really have no basis to ask for the court to modify the bond. It's a really technical matter. However, on the tampering or harassing charge, I would ask that the court consider a bond increase from 1,000 to 3,500, Your Honor. It was improperly booked as tampering in a misdemeanor proceeding, making it a third-degree felony. It's actually tampering with the witness or victim in looks like it's been filed as a second-degree felony, Your Honor, the aggravated battery, which it's being listed as a second-degree felony, Your Honor, but my understanding of the statute is tampering in any felony offense raises it to the next level, which would make that a first-degree felony, Your Honor.
Okay, thank you, Mr. Porter.
Judge, I was just going to ask if the court would leave the bonds as is. He has other no bond holds that are holding him in at this time, and he also the bonds without these two charges is at $8,100, which I'm not sure that he would be able to afford. So we would just ask the bonds be left as is or as was.
Thank you. I see that it was booked under tampering and misdemeanor proceedings, so it's been correctly now charged as tampering and secondary felony, which makes it a first-degree felony. So I am going to do that bond increase because the charges have been upgraded. So it'll be set at $3,500 on the tampering charge. I'll reinstate the $1,000 on the firearm by felon. Sir, you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes.
And as you were previously advised by Judge Murphy at first appearance, you shall surrender all firearms, weapons, or ammunition within 24 hours of your release to local law enforcement. Do you understand?
Understood.
All right. And you cannot have any contact with the listed witness, victim, direct, or indirect. Do you understand?
Yes.
That means no phone calls, text messages, emails, letters, having a family member or friend send a message to the listed victim or witness, or any other means of communication that I have not set. Do you understand?
Yes.
All right, and your office has already been provisionally appointed. Anything else in Mr. Hernandez's case?
No, Judge.
All right, good luck to you, sir. All right, so what else do we have at our Conti facility?
We have Mr. Lund.
Mr. Lund, okay, Mr. Lund, good morning, sir. This is a 3040 on the FMN docket. Mr. Linder, has the state filed charges?
Not at this time, Judge. Mr. Lund is entitled to an ROR on this charge.
All right, thank you. Mr. Forbear, do you need his phone number? You have it? Okay. All right, Mr. Lund, the state has not filed charges against you yet. That does not mean that they still cannot file charges. But for now, because they have not filed charges within a specified statutory period, you are entitled at least on your own recognizance. That means you're going to get out today. Please be in touch with your assigned public defender and or look on the clerk system to see whether or if the state files charges. Good luck to you, Mr. Lund.
Thank you, ma'am.
Okay, and I will delete the pretrial conditions as well, guys. If you could delete the pretrial GPS because he is just a straight ROR.
All right, boy, keep that up.
All right, so who else do we have at Conti? Sir, good morning. What's your name?
Christopher Washington.
All right, this is Mr. Washington on this second look docket. It's $100 KPS. Mr. Linder, does the state have an offer just to resolve?
Documented offer from the state judge is a withhold and court cost. I'm not showing any prior DWSs.
Okay, thank you. Mr. Farber, do you need a moment to speak to him or do you want to ask him on the screen?
No, Your Honor, I already spoke to him. He wishes to try to resolve it, so he would accept that.
All right, thank you. Mr. Washington, please raise your right hand for me, sir. Do you swear or testify to the truth, the whole truth, and nothing but the truth?
That's what I do.
All right, thank you. You can put your hand down and state your name for the record.
Christopher Washington.
All right, Mr. Washington, it's my understanding you wish to resolve your driving with suspended license case today, correct?
Yes, ma'am.
And do you understand the charge against you?
Yes, ma'am.
Do you understand everything that's happened here today?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of alcohol or drugs, sir?
No, ma'am.
Do you need more time to speak to your attorney?
No, ma'am.
Do you understand you have a right to go to trial, but you're forever giving that up by accepting the state's offer?
Yes, ma'am.
Have you ever been treated for a mental or emotional illness, sir?
No, ma'am.
I'm not asking if you're a United States citizen. I just have to advise everybody that comes before me. Do you understand if you're not a United States citizen, that taking a plea today shall subject you to deportation proceedings, sir?
Yes, ma'am.
And how do you wish to plead, guilty or no contest?
No contest.
All right, sir, I accept your no contest plea is freely, voluntarily, knowingly given. I find there's also a factual basis for this plea. I'll sentence you to withhold of adjudication and court costs. And also I must remind you and advise you, Mr. Washington, that upon a third conviction for driving with license suspended, it may result in a mandatory 10-day jail sentence pursuant to Florida statute. Do you understand?
Yes, ma'am.
And also may result in a third within 5 years, may result in a 5-year driver's license suspension and you being declared a habitual traffic offender through the DMV. Do you understand?
Yes, ma'am.
There's also another potential that a third arrest for driving with license suspended could result in you being charged with a felony. Do you understand?
Yes, ma'am.
Knowing all that, do you still wish to maintain your no contest plea?
Yes, ma'am.
All right, thank you, sir. How much time does he need to pay, Mr. Barbaric? All right, and I'll give you 1 year to pay court costs, cost of prosecution, PD application fee. Good luck to you, Mr. Washington. If nothing else is holding you, you should be released today.
Yes, ma'am. Thank you.
Of course. Next is Mr. I believe Bally.
Thank you, ma'am.
Quarantine, so we'll come back to him. All right, thank you. So let's go to North Broward. All right, good morning. This is Mr. Coakley, correct? Sir, you Coakley?
Correct.
All right, good morning, sir. Mr. Linder, this is a motion for 3040. Has the state file charges?
Information has been filed, Judge.
All right, thank you. So Mr. Coakley, at this time, the state has filed an information against you, so your motion for ROR will be denied. Please be in touch with your attorney so that they can let you know the next steps in the proceedings. Is there anything else in his case that we need to address?
No, Judge.
All right, good luck to you, Mr. Coakley. All right, let's go over to Paul Ryan.
Yes, Your Honor.
All right, who do you guys want me to call first?
Hatter, Your Honor.
Hatter, okay, Miss Hatter is on page 5. Just give me 1 minute to get her PCs. right, Ms. Hatter, good morning, ma'am. This is a change of charge. The state has filed an information against you. You were originally charged with leaving the scene of an accident with death. The state has now filed an information charging you with driving under the influence manslaughter, UVAL, and driving under the influence manslaughter impairment. I see that the original bond set on 5/28 this year was $75,000 for the count of leaving the scene of the accident with death. Let me first turn to Mr. Linder.
I spoke to Mr. Weiner this morning. My understanding is these are actually change of charges from the misdemeanor DUI counts. Since her first appearance, the state got the lab results back, or the blood results back, Your Honor. I can advise the court that her blood tested positive for ethanol and THC. One moment, Your Honor. The specific results. One sample was taken at 2:27. The crash was at 10:07 in the evening. One sample was taken at 2:27 in the morning. Her blood alcohol was a 0.166, and there was THC in her system. Another sample was taken at 7:49 in the morning, and her blood alcohol content was 0.086, and still, obviously, there was THC in her system, Your Honor. As I mentioned, I spoke to Mr. Weiner this morning. In addition to the $75,000 bond that the court made reference to, she also has a $10,000 bond on no valid DL causing death, $1,000 on the DUI property damage, and $10,000 on leaving the scene. Additionally, she has multiple no bond holds from Lake County. Your Honor, the state would be seeking a $50,000 bond on each of these counts, with the same release conditions that were set at her original first appearance.
Okay, thank you, Mr. Farber.
Judge, the total amount of bonds without.
You're muted, so she can't hear you. Let me turn this down if you need me to. Go ahead.
Yeah, the total amount of bonds, Judge, without these two is over $96,000. She also has those no bond holds. She's not going to be able to post any bond at this point. I would just ask the court to set the bond as low as possible.
All right, thank you. So, Ms. Hatter, I am going to set your bond on each of the driving under the influence counts with death at $50,000. If you are able to post your bond, ma'am, you are going to be supervised by pretrial release level 1 as originally set by the magistrate judge who you came before on the 28th of May. But you also cannot use any drugs or alcohol while your case is pending. Do you understand? And you are going to be randomly screened for drugs and alcohol while your case is pending, as originally told to you at first appearance. Do you understand?
Yes.
Okay, and was there a minimum amount? I didn't see that.
I'm sorry, Your Honor?
I believe there's been a change in circumstance, Mr. Linder and Mr. Corbett, because I don't believe the court at the time had the blood or the blood results. So I am.
Oh, absolutely. There.
Okay, so I am going to order random screens at a minimum of 2 times per week, because of the change in circumstance. And ma'am, you cannot drive while this case is pending, specifically because you're going to be on house arrest. You understand?
Yes.
And all other previous terms and conditions apply. I believe there was a passport surrender that was also done by the previous judge. Anything else on her case we need to address?
No, Judge.
Select you, ma'am. Oh, that one didn't sign as well. It's very tiny. All right, so who else do we have there? Paul Ryan?
Miller, come on.
All right, good morning, ma'am. What's your name?
Samantha Miller.
Samantha Miller. Okay, this is Miss Miller on the second lip docket. Mr. Linder, it's a petty theft. Does the state have an offer?
One moment, Your Honor.
Thank you.
It offers adjudication, time served, no return to the Walmart, 5555 West Atlantic Boulevard in Margate, Your Honor.
Do you know which theft this is?
One moment, Your Honor.
Okay, thank you. While he's looking that up, Mr. Farber, do you know what she wishes to do?
In speaking to her this morning, she indicated that she wanted to resolve the case today, so she would accept the offer.
Okay,
And
thank you so much.
I'm showing prior thefts in 2009 and 2010.
Okay, thank you. All right, ma'am, please raise your right hand for me to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth? Sorry, I can't hear you.
Yes.
All right, thank you. Can you please state your name for the record, and you can put your hand down.
Samantha Miller?
All right, Ms. Miller, it's my understanding you wish to resolve your petty theft charge today, correct?
Yes.
Do you understand the charge against you?
Yes.
Do you understand everything that's happened here today?
Yes, Your Honor.
Is anyone forcing you to resolve this case?
No.
Are you under the influence of alcohol or drugs today, ma'am?
No.
Do you need more time to speak to your attorney?
No.
Do you understand you're giving up your right forever to fight this charge and go to trial by accepting the state's offer?
Yes.
Have you ever been treated for a mental or emotional illness, ma'am?
No.
I'm not asking if you're a citizen. I just have to advise everybody that comes before me for a plea. Do you understand if you're not a United States citizen, by accepting this offer, you shall be subjected to deportation proceedings if you're not a United States citizen?
Yes.
All right, and I also must advise you that this is a third arrest for a theft. If you get any more arrests for petty theft, you may be charged with a felony petty theft or receive jail or prison time if convicted as charged. Do you understand?
Yes.
And knowing all that, Ms. Miller, how do you wish to plead, guilty or no contest?
No contest.
All right, Ms. Miller, I accept your no contest plea is freely, knowingly, voluntarily given. I also find there's a factual basis for this plea. I am going to sentence you to an adjudication, time served, no return to the Walmart in the police reports. And how much time does she need to pay, Mr. Farber?
He asked him for 1 year.
Not a problem, and I'll give you 1 year to pay those court costs, cost of prosecution, PD application fee, Mr. Miller. Good luck to you. If there's nothing else holding you, you should be released today, ma'am.
Thank you.
No problem. And last but not least is Mr. Jean Baptiste, or Miss Jean Baptiste also. All right, good morning, ma'am. Mr. Linder, this is Miss Jean Baptiste on the second page of the FMN docket. It's a 3040 motion for release.
Information has been filed, Judge.
All right, thank you. So at this time, Ms. Jean Baptiste, the state has filed an information against you, so your motion for ROR will be denied. Please be in touch with your attorney so they'll let you know the next steps in the proceedings. Anything else on her case that we need to address?
Yes, her bond is now $1,000.
Okay, thank you. So it was reduced?
Follow everything.
Oh, okay.
Charge that $1,000.
Okay. Thank you, Ms. Cooper. So Ms. Jean Baptiste, your bond is now $1,000. Only one of the charges with that bond was filed. So now your total bond is $1,000, okay?
Okay.
All right, good luck to you, ma'am. All right, so while we wait for the Spanish interpreter, let me start with my private attorney cases. On page 1, I have Ms. Messier on Ms. Rastetter is here on her behalf.
Sorry, good morning, Your Honor.
Good morning. Just give me 1 minute. Guys, I need the DV contact orders, please. When you get a chance, just switch with me. Thank you so much. That's a good step. All right, good morning, ma'am. All right, good morning, Ms. Messier. I do find probable cause for battery, cause bodily harm, domestic violence. Mr. Linder, I will first turn to you and then Ms. Rastetter.
Your Honor, I believe counsel and I have an agreement if it's acceptable to the court.
Sure.
We've agreed to $1,000 bond, no victim contact. I checked. I do not see any history from Ms. Messier.
That's correct, Your Honor.
All right, thank you so much. All right, ma'am, I am going to set your bond in the amount of $1,000. The conditions of your bond, even while you're in custody, you cannot have any contact with the listed victim, direct or indirect. Do you understand? Yes. That means you cannot live with the listed victim. You cannot call, text, email, social media, send letters, have a family member or friend, or any other means of communication that I have not said with her. Do you understand?
Yes, ma'am.
You also cannot possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature. Do you understand?
Yes.
All right, is there anything else on her case that we need to address?
No, Judge.
All right, thank you. Good luck to you, ma'am. Nice to see you, ma'am, Ms. Rastetter.
Thank you.
All right, just give me 1 minute to finish filling these out, and then I'll get to Mr. Davenport is going to be the next case that we handle. Just let me finish filling out this these orders.
In the court. Okay.
All right, so next is Mr. Davenport on page 25.
We're Maureen Mompoint on behalf of Mr. Davenport.
Good morning, Ms. Mompoint. Nice to see you, ma'am.
Hi, Judge.
All right, so Mr. Davenport, good morning. We reset your case yesterday for your attorney to be here, and Ms. Mompoint is here on your behalf. I do find probable cause for, it actually should be attempted murder. It just says murder on the docket. Count 1 is attempted murder in the first degree with premeditation. Count 2 is a burglary of a dwelling armed. And I also make a finding of proof evident, presumption great. And at this time, I am going to hold you no bond. You're going to have to go before your division judge within which to have an Arthur hearing heard. It's the allegations are that you are the alleged shooter. So you'll have to file a motion with your division judge because at this time I'm holding you no bond. You can, the conditions of your custody, sir, or that you cannot have any contact with the listed victim, even while you are in custody, direct or indirect. You understand?
Yes, we can go.
Yes.
All right, that means you cannot call him, you cannot send letters, you cannot have a family member or friend send a message to him or any other means of communication, even while you're in custody. Understood? You also cannot have any co-defendant contact. Do you understand, direct or indirect?
Yes.
All right, and so Mr. Linder, I will need to keep separate order, please.
Yes, Judge.
All right, and if your division judge does release you from custody, sir, you cannot return to the listed victim's home. There will be a no return order in place. Do you understand?
Yes.
And you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand? Okay, is there anything else on his case that we need to address today?
I just wanted to make on the record that it is presumption great without prejudice, so we are able to go forward with an Arthur hearing if necessary.
Yes, absolutely. It is always without prejudice at first appearance so that he has that opportunity to file a motion with his division judge.
Thank you so much, Judge.
Thank you. Nice to see you.
You too.
Thank you. Take care. All right. So do we have any other private attorneys that are in the courtroom? Otherwise, we're going to start on page 1. All right, hearing nothing, let's continue on page 1. We have Ms. Abbasi on page 1.
She is here at main, Judge, approaching.
All right, thank you. Ma'am, good morning. I do find probable cause for touch or strike battery, domestic violence. Mr. Linder, first to you, sir.
Judge, I'm recommending $1,000 bond, no victim contact. While I see no local history, this is based on the allegations in the probable cause affidavit.
Okay, thank you. Mr. Romero, sir.
Judge, I spoke to Ms. Abbasi. She's been residing here in our community for a number of years. As the state advised, she has no prior record. This is the first time she's ever been arrested in her whole entire life. Now, she does live with the alleged victim. I did advise her the significance of a no contact order. She will be abiding by that. Unfortunately, she advised me when she was arrested, she didn't have an opportunity to have her phone with her. She has no numbers memorized, so unfortunately, she has no one to call to post her monetary bond. Based on her lack of criminal prior, Judge, I was going to ask the court to consider releasing her ROR or in the alternative ROR to pretrial.
Based on the level of violence, she's not a candidate for straight ROR. I will release her to pretrial release, but she's going to be randomly screened for alcohol and drugs based on there being the alcohol influence box checked off. Ma'am, you're going to be released today, but you have to call to pretrial release before 11 a.m. tomorrow. So please give your phone number to pretrial before I continue with my orders.
Give them your phone number right now.
305
Louder, please.
905-7852.
Did you get that, Ms. Moore? All right, ma'am, you can use any drugs and you cannot use any alcohol while your case is pending. Do you understand? Based on the level of violence, you're going to be randomly screened at least one time per week while your case is pending. Understood? And you cannot have any contact, direct or indirect, with a listed victim. Do you understand? Sorry, she's very soft-spoken.
He answered in the affirmative, Judge.
All right, thank you. That means that not only can you not live with him, you cannot call him, text him, email, social media, send a family member or friend to send a message to him, or any other means of communication that I have not said. Do you understand?
Yeah.
All right, ma'am. I also cannot, you also cannot, how do I unmove this pin? Okay, you also cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yeah.
Okay, and that's based on the domestic violence nature. Does your office need to be provisionally appointed, Mr. Romero?
No, she's going to retain private counsel, Judge.
All right, good luck to you, ma'am. You're going to be released today. You need to call in tomorrow before 11. All right, next is Ms. Poole on page 1.
She's approaching, Judge.
Okay, thank you. All right, Ms. Poole, good morning, ma'am. I do find probable cause for battery, cause bodily harm, domestic violence. Mr. Linder, first to you, sir.
Judge, I'm recommending a $1,000 bond, no victim contact. She has a pending possession of cocaine that I believe and prostitution that I believe Ms. Worrell has some information on.
Okay, my apologies, Ms. Worrell. Yes, ma'am.
Yeah, the defendant was released for pre-trial standing supervision in case number 20357 CF10A, one count of possession of cocaine. And the second count was offer of the secure act of prostitution. The defendant stopped taking the pre-trial made April of this year at this time. Sexual representation of prostitution.
And
That was 2357.
Yes, Your Honor.
Okay, thank you. Mr. Linder, first to you on that request.
yes, Your Honor, I'd ask that you grant a pretrial's request, set the bond on the possession of cocaine at $1,000, no bond attached on the prostitution. Because additionally, Your Honor, Ms. Poole was arrested last year for aggravated battery with a deadly weapon against the same alleged victim. That was dropped. She was arrested in 2017 for felony battery against a victim over the age of 65. That was dropped. Prostitution 2016, theft 09, resisting without violence 05. Nothing further, Judge.
Thank you, Mr. Romero.
Judge, considering what we just heard, I just spoke to Ms. Poole. At this time, we're just asking to be provisionally appointed, no objection to the $1,000 bond on the new law offense. She does realize the significance of the no contact order. She does not live with the alleged victim. And as far as taking action on the case, no objection to setting a $1,000 bond on the case that she's currently out on supervision.
All right, thank you. So I will grant pretrial's request and set a $1,000 bond back on the cocaine possession and ROR on the prostitution offense. So that will be revoked. All right, and on the new law, ma'am, $1,000 bond, the conditions of your bond, even while you're in custody, Ms. Poole, you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
I do, ma'am.
All right, that means that not only can you not live with him, you cannot call him, text him, email, social media, have a family member or friend send a message to him, or any other means of communications that I have not said. Do you understand?
Yes, ma'am.
All right, does your office need to be provisionally appointed, Mr. Romero?
Yes, Judge.
All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you will need to reapply if this case is still pending. Anything else on her case?
No, Judge.
All right, good luck to you, Ms. Poole.
Here's the phone number of the PD. Call it, contact your assigned attorney.
All right, next is Ms. Hamlet on page 1.
Come on up, Ms. Hamlet. She's here present.
Thank you, Ms. Hamlet. Good morning, ma'am. I do find probable cause for touch or strike battery, domestic violence. Mr. Linder, first to you.
Your Honor, I see no history. I'm recommending an ROR to pretrial, no victim contact.
Okay, thank you, Mr. Romero.
Judge, that's exactly what we're going to be asking for.
All right, thank you. Ms. Hamlet, you're going to be released, trial release. That means that you're going to get out today, but you have to call in tomorrow before 11 a.m. So please provide your phone number to pretrial before I continue with my orders.
954-683-3849.
All right, Ms. Hamlet, the conditions of your pretrial release, ma'am, are that you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Yes, ma'am.
That means that not only can you not live with him, you cannot call him, text him, email, social media, have a family member or friend send a message to him, or any other means of communications I have not said. Do you understand?
Yes, Your Honor.
You also cannot possess any firearms, weapons, or ammunition while your case is pending based on a domestic violence nature. Do you understand?
Your Honor.
And does your office need to be appointed?
Yes, Judge.
All right, thank you. And I will also provisionally appoint the Office of the Public Defender to represent you during the pandemic, ma'am. Once COVID is over, you will need to reapply if this case is still pending, okay?
Yes, ma'am.
Good luck,
Thank you.
Hamlet. Please call in tomorrow.
Before 11 a.m. Okay, good luck, ma'am.
Next is Ms. Stanley on page 2.
He's approaching, Judge, here, Maine.
All right, thank you, Ms. Stanley. Good morning, ma'am. I do find probable cause. It's backwards for some reason. Count 1 is false imprisonment of an adult. Count 2 is aggravated battery. Offender knew or should have known victim was pregnant. Count 3 is burglary with an assault or battery. I do make a finding of proof evident presumption great, but I do so without prejudice. Let me hear from you first, Mr. Linder.
Your Honor, I did speak with Ms. Donaldson, the alleged victim, this morning. She would like the court to issue a no contact order, but she does not have an objection to the court setting bonds. I'm going to be recommending a $2,500 bond on the false imprisonment, a $5,000 bond on the battery on a pregnant victim, and $7,500 bond on the burglary with the battery, for a total bond of $15,000 with an order of no victim contact. The only prior I saw, Your Honor, was a 2006, I'm sorry, she had a 2006 grand theft, a 2006 petty theft. Nothing further, Judge.
All right, thank you, Mr. Romero.
Judge, I spoke to Ms. Stanley. Even though the state has no objection as far as setting monetary bond, I'm going to be also asking the court to exercise its discretion and impose a monetary bond and not impose a no bond hold on count 1. In speaking to Ms. Stanley, she's been residing in our community her whole entire life. She does not work. She gets disability, so she is on a fixed income. She receives approximately $700 a month. She lives separate and apart from the alleged victim. She understands and will be abiding by the court's order as far as no contact, direct or indirect. Now, she is a single mother. She resides in Coral Springs, where she rents an apartment. As you heard, Judge, she does not have significant contact with the criminal justice system. She is not, from my understanding, she is not a convicted felon. I believe the only contact with the system she had was around when she was around 18 years old. Judge, she's not going to be able to afford what the state has asked for. I believe a total of $15,000 bond. What we are going to be asking for is a total of $5,000 bond. We understand the seriousness of the allegations, and based on the seriousness, we wouldn't object also if the court wanted to impose an added layer of security as supervision and have Ms. Stanley supervised, but she cannot afford a $15,000 bond at this time, and I'm going to be asking to be provisionally appointed.
All right, thank you. Based on this being a life felony, if convicted as charged, I find the state's request to be very reasonable. But however, I am going to put her on a level 2 monitor because again, she is facing life in prison if convicted as charged. Based on these allegations, she allegedly punched the listed victim multiple times in her stomach, knowing she was pregnant. So I am going to set bond as requested by the state because the listed victim has advised the state that she is okay. And this is only because the listed victim has advised the state that she is okay with the court setting bond. Otherwise, she would have been held no bond. So on count 1, bond's going to be set in the amount of $2,500. Count 2, $5,000. Count 3, $7,500. If she's able to post that bond, pretrial release level 2 with the GPS for the records I put forth on the record, the reasons. And ma'am, if you do post bond, you cannot return to the listed victim's home. Do you understand?
Yes, I was never at her home.
We'll talk about the facts of the case, ma'am. Do you understand? Don't return to the incident location. Do you understand?
Yes.
If you have any contact, direct or indirect, with the listed victim, that means that not only can you not go by where she's living, you cannot go by where she's working, or if she's going to school or the doctor's appointments, you cannot call her, text her, email, social media, letters, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
She answered in the affirmative, Judge.
You also cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, Ms. Stanley. Once COVID is over, you will need to reapply to make sure that they keep representing you. I have no contact. Okay, thank you. Anything else on her case?
No, Judge.
You said 2,500, 5,000, 7,500?
Yes, ma'am. They were just recapping the bonds. Good luck to you, ma'am. All right, next is Ms. Lind on page 3.
I'm sorry, Your Honor.
Thank you, Ms. Lind. Good morning, ma'am. I do find probable cause for battery on a person 65 years or older, 2 counts. Mr. Linder, first to you.
Just one moment, Your Honor. My office had contact with the alleged victims yesterday. I just wanted to pull that email so I can see what information they relayed to us. Okay,
Three more.
Your Honor, both of the alleged victims advised that they want Ms. Lynn to get treatment at a long-term facility. They advised that she's had several hospital stays. They want no contact. They did advise of mental health issues, Your Honor. I'm not going to go into any specific diagnosis they mentioned for Ms. Lynn's privacy. Your Honor, I can also advise the court that while I know it doesn't state it in the PC, I can mention as an officer of the court, the alleged victims in this case are 82 and 86 years old. The way I know this is Ms. Lynn was arrested earlier this year for battery, 2 counts of battery against a victim over the age of 65 and tampering with a witness or victim. It was the same alleged victims in that case. I pulled the probable cause, the sworn probable cause affidavit from that case, which listed both victims' dates of birth. Additionally, Your Honor, Ms. Lynn was arrested in 2016 for a felony battery against a victim over the age of 65 and misdemeanor battery. Listed the alleged victim in that case was her father, who's one of the listed victims in this case. Those charges were dropped. She did plead out to a reckless driving with priors in the 2016 felony case. Judge, based on her previous arrest and one as recently as this year against both alleged victims and the vulnerability that these victims have based on their age, I'm recommending a $5,000 bond on each count and no victim contact.
Did you say the case from earlier this year was dropped?
Yes, it was dropped March 18th, Your Honor.
Okay, thank you. Mr. Farber?
Judge, I can tell the court that she's lived here for approximately 10 years, that she does have some money to post bond. I would ask for the court to set up basically $1,000 or $1,500 with regards to each count.
All right, thank you. Does your office need to be provisionally appointed?
We would be for now, Judge.
Okay, thank you. All right, so I am going to unmute her now, but Ms. Lind, just listen very closely, okay? I am setting your bond in the amount of $5,000 per count. The conditions of your bond, ma'am, even while you're in custody, you cannot have any contact with either of the listed victims, your parents. Do you understand?
Oh, this is for my mother and father, Murray and Harold Lynn?
It is for both of your parents, correct? Mother and
Very
father
good.
cannot have any contact with either of them, direct or indirect. Understood?
Yes.
All right, also that means that not only can you not live with them, meaning you cannot return to the listed property, you cannot call them, text them. Mr. Farber, I muted you because it's the echo.
Okay.
Okay, thank you. You cannot call them, text them, email, social media, send letters, have a family member or friend send a message to them or any other means of communication that I have not said. Understood?
Yes.
You also cannot possess any firearms, weapons, or ammunition while your case is pending based on domestic violence nature. Understood?
I don't know any of that.
All right, not a problem. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic.
My general counsel, John Menzel, will be my attorney.
Okay, so whenever he does file in, he'll be a substitution of counsel, but he needs to file a notice of appearance. So
Okay.
until that happens, I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. And once COVID is over, you'll need to reapply if that attorney has not filed in, and you need to continue to need the services. Okay.
COVID over.
I'm sorry, ma'am.
I was vaccinated, but I'm not understanding when you're saying when COVID's over. What do you mean by that?
When we're no longer in a state of emergency.
Oh, we're in a state of emergency in the state of Florida?
We have been since March 2020. Good luck to you, ma'am. All right, next is Miss Woolley on page 4.
Here, President Judge Jermaine.
All right, thank you, Miss Woolley. Good morning, ma'am. I do find probable cause for a violation of an injunction. The allegations are that she was allegedly at the victim's home at 3:38 a.m. in the morning. Mr. Linder, any priors in the state's recommendation?
Your Honor, this is actually a violation of a no contact order from a pending felony battery due to priors.
I need that case number, please.
19-14081 CF10A. It does involve this, obviously it does involve the same alleged victim.
So it's both. Okay, give me 1 minute.
Sure.
All right, Ms. Woolley, on January 9th of 2020, you were advised to not have any contact, direct or indirect, with the listed victim, I am going to revoke your bond in 19-014-081 CF10A because you have violated the conditions of the court's no contact order by being at the victim's home at 3:38 in the morning. You're going to be held no bond on that case. On the new law, I am setting bond in the amount of $10,000. If you're able to post bond, you're going to be on pretrial release level 1 with a GPS strict house lockdown. Again, no contact, Ms. Woolley, means that you cannot call, you cannot text, no emails, social media, letters, pigeon carriers, messages in a bottle, any other means of communications that I have not said. Do you understand?
Yes, ma'am.
You also cannot be at or near the victim's home. Do you understand?
Ma'am, can I say something in regards to
No,
that?
ma'am, you cannot talk about the facts of your case because anything you say is being recorded and can and will be used against you. Do you understand?
Yes, ma'am.
You also cannot possess any firearms, weapons, ammunition while your case is pending based on the domestic violence nature. Do you understand?
Yes, ma'am. We're here.
All right, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic based on the court's no bond hold. Once COVID is over, you'll need to reapply to make sure they keep representing you. Good luck to you, Ms. Woolley.
Judge, if I may, I still have to make my record, and I have to, and speak Ms. Woolley. My understanding is, yes, she is aware that she's here on an injunction. We did talk about that. But unfortunately, as you see, she's been out on that case since 2019. It was at the request of the victim that she returned to the home. They share children in common, and Ms. Woolley was the person taking care of her children. Now, she's been residing here her whole entire life. She has a mother that resides here in the county that she can live separate and apart. Rather than, I know the court is taking action, but rather than holding her no bond, which is the most severe sanction this court can impose, I'd ask the court to consider a level 1 pretrial house arrest so that she could reside with her mother and impose level 1 on the new law offense as well. And I'll be asking to be provisionally appointed, Judge.
All right, thank you. I understand your request. I've ruled. Good luck to you, ma'am. Is there a domestic violence no contact for this Woolley case? I don't have one here. Please prepare one for me so that it's very clear. Okay. Thank you. All right, next is Miss Leona on page 4.
No crowd, Your Honor.
All right, thank you, ma'am. Good morning, ma'am. I do find probable cause for your out-of-county hold from St. Lucie County. It's a probation violation regarding a DUI, impairment, blood or breath alcohol. You're being held no bond. You're going to be transported to St. Lucie County to answer to these charges. Anything else on Ms. Leona's case?
No, Judge.
Good luck to you, ma'am. Next on page 6, Ms. Bacon.
No crowd.
No, okay, Ms. Bacon. All right, Ms. Bacon, good morning, ma'am. I do find probable cause for possession of cocaine and drug paraphernalia. Mr. Linder, first to you.
Judge, I'm asking that the court keep the bond in place. Ms. Bacon just appeared before the court on July 8th, last week, for delivery of cocaine. Your Honor kept the bond in place at $2,500. She posted bond and was released on July 11th.
Okay, thank you, Mr. Barbera. Okay, thank you. So I will leave the bond in place, Ms. Bacon, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Ms. Bacon, once COVID is over, you will need to reapply to make sure that the Public Defender's Office keeps representing you. Good luck to you, Ms. Bacon. I'm leaving the $1,000 bond in place. All right, next is Ms. Hogan on page 6, who has refused. We are proceeding in absentia on her voluntary refusal. Ms. Buckaloo is here on behalf of the state and Mr. Romero is here on behalf of the defense. I do find probable cause. There is a signed warrant charging her with murder in the first degree, premeditation, 2 counts. I am finding a proof evident presumption great based on the allegations. I am going to hold her no bond. She will have to go before her division judge in order to have her division judge hear an Arthur hearing and make any determinations as to bond. I'm ordering no possession of firearms, weapons, or ammunition while her case is pending. And I'm also ordering that she not have any contact with any minors under the age of 18 while her case is pending. Is there anything else on Ms. Hogan's case that we need to address?
Yes, Your Honor. I'd just like to ask for the court to
order sealing the warrant and affidavit for the 90-day period due to the fact that although probable cause has been found, it is still a pending investigation with more work that needs to be done. And any information in that affidavit being released right now could taint any potential ID or witnesses.
Okay, thank you, Mr. Romero. Do you have a legal objection?
My colleague will address it.
Judge, I have no objection to that.
Okay, thank you. So I will sign an order sealing it, and I will provisionally appoint the Office of the Public Defender to represent Hogan during the pandemic. Anything else, Kate?
Thank you.
Judge, also, we would invoke the defendant's rights to remain silent and not to be questioned by law enforcement unless she's with her attorney.
All right, thank you.
The record is noted. Thank you.
Honor? So I didn't catch the name of the attorney that appeared representing Mr. Davenport.
It's a Milena Mompoint.
Thank you, Judge.
I used to supervise her a long time ago.
That long, yeah.
Like over 11, 12 years ago. All right, so I'm going to give a copy to Ms. Cooper in confinement, and then thank you. And then sorry. And then 2 copies for the clerk's office. All right, thank you. So that brings us to Ms. Cook on page 7, who is a second-time refusal. We're proceeding without her. I do find probable cause for possession of cocaine and drug paraphernalia based on her refusal. I am going to leave the bond in place, and I will provisionally appoint the Office of the Public Defender to represent her during the pandemic. Once COVID is over, she'll need to reapply. Anything else on Ms. Cook? Okay, thank you. Next is Mr. Crosby on page 8, and the listed victim is outside, so just give them a minute to get the listed victim. Well, I guess one of the listed victims, because there's multiple. All right, while they're doing that, I will make a finding of probable cause for 2 counts of battery, cause bodily harm, domestic violence, and dating violence. So just give me 1 minute. All right, good morning, ma'am. What is your name for the record? All right, ma'am, and you are one of the listed victims, and you are here without an attorney. So I just needed to ask you, are you here to see what's going to happen, or did you want to tell me something?
I wanted to tell you something.
Okay, so please raise your right hand for me. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth? Okay, thank you. You can put your hand down, and now that you're sworn, please state your name again. All right, ma'am, you are one of the listed victims again, but you're here without an attorney, so I need to advise you that you previously spoke with law enforcement, so anything you say today can be used against you at a later date. Do you understand?
Yes.
Okay, thank you, ma'am. What is it that you wanted to tell me?
I wasn't a victim that night. We didn't have any physical altercation. What was told to the police that night, that's what I told the police that night, and what was told to them that got me on the record was said by someone who was there that night. It was late at night, so I think that representation. So there was no actual physical altercation.
All right, thank you, Ms. Mohammed. Does either party have any questions for her based on her testimony this morning?
No, Judge.
I do, Judge. Ma'am?
Go ahead.
Are you in fear of Mr. Crosby?
No.
Was that a no?
She said no.
That was a no.
Do you want contact with Mr. Crosby?
I'm sorry, I can't hear you.
Do you want contact with Mr. Crosby?
One more time.
Do you want contact with Mr. Crosby?
Yes.
Yes? No further questions, Judge.
All right, thank you for being here, ma'am. All right, so Mr. Linder, first to you, sir.
Your Honor, I see no history. I'm recommending an ROR to pretrial on both counts. Random testing. I would be asking for a no contact order at this time, Your Honor. I think based on the allegations of what led to the alleged battery, that according to the report, his mother advised law enforcement of what she witnessed, and then his conduct once he was taken into custody, I think a cooling off period would be appropriate.
Okay, thank you, Mr. Romero.
Judge, no objection to the ROR to pretrial. Judge, but I would be wanting to address the no contact order. My understanding, we heard from one of the victims here today under oath, and I believe the other victim is her sister, who is of, I believe, similar viewpoint. Mr. Crosby does want contact with his girlfriend and his family, Judge. You heard from the victim, she is not in fear. She also wants contact. My understanding, Judge, it was not the alleged victims who contacted law enforcement. My understanding is when law enforcement responded and Mr. Crosby was going to be incarcerated or placed under arrest, neither victim wanted to see Mr. Crosby arrested, and I don't believe they want to go or proceed forward on these charges. My understanding, speaking to Mr. Crosby, he's a lifelong resident of South Florida. This is the first time ever being arrested in his whole entire life. So, Judge, I'm asking for our order of pretrial and for the court not to impose a no victim contact order.
Okay, thank you. So with regards to Ms. Mohammed's charge, I will ROR him to pretrial. However, with regards to the other listed victim, without them here, I am setting bond in the amount of $500 plus pretrial release. Once you do post bond and you need to call in a pretrial release, so please give your phone number to pretrial before I continue.
619296480.
What are the first three, please?
561.
561. Okay, thank you. Sir, based on the allegations that this was allegedly a physical altercation based on alcohol and drugs, you were allegedly under the influence of 2 bottles of alcohol in a fight over cocaine. You are going to be randomly screened at least 2 times per week while your case is pending, and you cannot use any drugs or alcohol while your case is pending. Do you understand?
Yes, ma'am.
All right. You also cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes, ma'am.
And for now, there needs to be a cooling off period. You cannot have any contact, direct or indirect, with either of the listed victims while your case is pending. Do you understand?
No, ma'am, I do not. I do understand your statement, but I believe I should be able to have contact because she just got finished saying that I should. And my sister, she's not here. I'm not sure where she is, but they were both.
You're telling me you're not going to stay away. I'm putting you on level 2 with a GPS monitor so we can make sure you're staying away from the listed victims, Mr. Crosby. You're telling the court that you don't understand why you cannot, and you're advising me that you're not going to stay away from her.
Judge, I don't believe he advised that he's going to stay away. He was just confused considering that none of the victims wanted to go forward. So he was requesting the court to reconsider and not impose a no contact order. But if the court does, I went over it with him, he will be abiding by that no contact order. He has no intention of not obeying a court order, Judge.
That's not what I heard, Mr. Romero. So let me try this again. Mr. Crosby, do you understand? I have not heard from the second alleged victim. I've only heard from one today, and I've just advised you there needs to be a cooling off period. So you cannot have any contact, direct or indirect, with either of the listed victims. Do you understand?
Yes.
That means that not only can you not live with either of them, you cannot call, text, email, social media, send letters, have a family member or friend send a message to either of them or any other means of communication that I have not said. Do you understand?
Yes.
And you will be abiding by my court order and staying away, correct?
Yes, ma'am.
All right. Does your office need to be provisionally appointed?
Yes, Judge.
All right, so I will provisionally appoint the public defender's office to represent you during the pandemic, sir. Once COVID is over, you'll need to reapply to make sure they keep representing you. I'll leave it at standard pretrial for now. But Mr. Crosby, please note that there is a stay away order and it has not been altered by a division judge. That is the only way that you could have contact is if your division judge changes this court's order. Good luck to you, sir. Good luck to you, ma'am. Well, he has to postpone first. Okay. 5 ROR on the first count regarding Ms. Mohammed and 500 on the second victim. Plus pretrial. Next is Mr. Bahena on page 8.
He's here, present, Judge. Amen.
All right, thank you. Good morning. I do find probable cause for battery, cause bodily harm, domestic violence. Mr. Linder, first to you.
Your Honor, I'm recommending a $2,000 bond, no victim contact. It's based both not only on the level of violence and the injuries that the victim allegedly suffered, but also the paperwork indicates that Mr. Bahena resides in the state of Illinois and lacks ties to the community. I don't see any local history.
Thank you. Mr. Romero.
Judge, that is correct, Judge. Mr. Bahina is from Chicago. Him and the alleged victim did travel down here together for vacation. My understanding, they're from Illinois, specifically, I believe, Chicago area.
30 minutes.
30 minutes from Chicago area, Judge. My understanding in speaking to Mr. Bahina, he has a clean record. He does work as a TV technician, only making approximately $300 a week. So the $2,000 bond is going to be financially difficult for him. Also, one other thing, Judge, he lost his phone. So unfortunately, he has no one to contact. I'll post his monetary bond. What we were going to be requesting is the court to consider setting a $500 bond on his behalf and to provisionally appoint my office in an order allowing him to go back to Chicago. He does understand not to have any contact with the alleged victim.
All right, thank you. Alcohol influence box was also checked off, so he's going to have to be randomly screened while he's in Chicago. All right, sir, I am going to set bond because of your lack of ties to the community, as well as the allegations that the victim was punched 4 times in her face allegedly after being pushed onto the bed at $2,000. Once you post your bond, you're going to be supervised by pretrial release, which means you'll have to call in 11 a.m. the next business day after you post bond. You can reside in Illinois while your case is pending, but please note you cannot possess any firearms, weapons, or ammunition while your case is pending based on domestic violence nature. Do you understand?
Yes, Your Honor.
You also cannot have any contact with the listed victim, direct or indirect. Do you understand?
Yes, Your Honor.
That means not only can you not live with her, you cannot call her, text her, email, social media, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
Yes, Your Honor.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure that they keep representing you. You're going to be randomly screened for drugs and alcohol, like I said, so no drugs and no alcohol. Good luck to you, sir.
Judge, one thing, I don't know if I heard correctly, you provisionally appointed my office?
I did, sir, yes.
I'm going to be requesting a property order, Judge.
Okay, property.
Thank you, Judge.
All right, no problem. Good luck to you, sir. Let me just write that on there. I don't know where. All right, thank you. Next is Mr. Dennis on page 8.
Judge, if I could just ask, Mr. Romero, that property order, was it to get to the cell phone?
To get his wallet.
Okay, thank you.
All right, Mr. Dennis, good morning, sir. Find probable cause for touch or strike battery, domestic violence. Mr. Linder, first to you.
Judge, I see no local history. I'm recommending a $2,000 bond, no victim contact. It's based on the level of violence alleged and the alleged injury suffered by the victim that caused her to seek medical treatment. Nothing further.
Thank you, Mr. Romero.
Judge, as you heard, Mr. Dennis has been residing in South Florida for over 30 years, more than half, almost half of his life. But more importantly, he has no prior criminal record. He's a registered voter in our community. He's self-employed. He does construction, only making about $250 a week. Considering this is a misdemeanor offense, his lack of priors, Judge, I do not believe that the victim wants to go forward. I'm going to be requesting the court to consider a $1,000 bond on Mr. Dennis' behalf and to sign a phone order so we can try and contact somebody to come up with that monetary bond, Judge.
Based on the level of violence and the alleged injuries that led her to seek medical care for her nose, top of her head, shoulder, back, head and shoulder, not back, sorry, scratch back. I find the state's request to be more than reasonable. I would set a $1,000 bond if you would also be subjected to pretrial release, Mr. Romero.
Judge, respectfully then, since he has prior record and he's going to have to come up or call somebody for a monetary bond, then $2,000 bond on his behalf. We're going to be asking to be provisionally appointed and still a phone order, Judge.
No problem. I'll sign that phone order. I will also provisionally appoint the public defenders to represent you during the pandemic, sir. Once COVID's over, you'll need to reapply to make sure they keep representing you. I will set your bond in the amount of $2,000. The conditions of your bond, even while you're in custody, Mr. Dennis, you cannot have any contact with the listed victim, direct or indirect. You understand?
Yes.
That means that not only can you not live with her, you cannot call her, text her, email, social media, send letters, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand? Sorry, a little louder.
Yes, ma'am.
All right, you also cannot possess any firearms, weapons, or ammunition while your case is pending based on domestic violence nature. Understood?
Yes, ma'am.
All right, anything else on his case? I've already said I'd sign that phone order.
Yeah, property order. He's going to try and see if maybe he has a credit card in his wallet.
All right, and I'll sign that property order as well. Good luck to you, sir. All right, I'll write it on here. Next is Mr. Felipe Auguste.
He's here, present, Judge.
All right, thank you. Good morning, sir. I do find probable cause for domestic violence injunction, willful violation. Mr. Linder, first to you.
One moment, Your Honor.
And I'll, I call him, never mind.
Your Honor, I'm recommending a $2,000 bond, no victim contact. As history, I see a 2019 possession of substituted cathinones, 04 grand theft, 04 burglary, dwelling, resisting with violence, battery on a law enforcement officer. Nothing further.
Thank you, Mr. Romero.
Judge, as you heard, he does have limited contact. I believe the contacts which were mentioned were not recent in nature. He's been residing here almost his whole entire life. He's not working. Judge, and speaking Mr. Philippe, Judge, my understanding is he was served with the injunction on the same day. He thought the person was not home. He was there simply to get clothes. He had every intention of abiding by that injunction. He even went ahead and basically made a reservation at a hotel in order to abide by that no contact order. He has every intention of still abiding by that no contact order. He's asking to be released ROR, and we're asking to be provisionally appointed.
Okay, ROR is not an appropriate request based on the an injunction being served on him that he admitted was served on him. I can put him on pretrial release level 2.
Judge, in that case, which is going to be present a problem, even though he's going to be at a hotel. I don't know how pretrial is going to go ahead and verify that might cause him to stay several nights here in custody. Then we're going to be no objection to the $2,000 bond then, Judge.
All right, I do object to that because I don't believe it's appropriate. He was served with an injunction, advised officers he was served with the injunction, yet was at the listed victim's home. So I am going to put him on a pretrial release level 2 with a GPS monitor because that's the only way I can ensure that he will stay away from the listed victim and her home. Sir, you cannot return to the victim's home. Do you understand?
Yes, Your Honor, I do.
You also cannot have any contact with her, direct or indirect. Do you understand?
Yes, Your Honor.
That means not only can you not go by where she lives, you cannot go by where she works. If she goes to school, you can't go there too. You cannot call her, text her, email, social media, send letters, have a family member or friend send a message to her, or any other means of communication that I have not said. Do you understand?
Yes, Your Honor.
You also cannot possess any firearms, weapons, or ammunition while your case is pending based on domestic violence nature. Do you understand?
Yes.
I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. It was a straight ROR to pretrial release level 2. Good luck to you, sir. Next is Mr. Robinson on page 8.
Is here present, Judge May?
All right, Mr. Robinson, good morning. I do find probable cause for touch or strike battery, domestic violence. Mr. Linder, first to you.
Judge, recommending a $1,000 bond, no victim contact based on the level of violence. The only priors Mr. Robinson has are dated drug possession priors. Nothing further.
Okay, thank you, Mr. Romero.
Judge, no objection, ask to be provisionally appointed.
All right, thank you. Mr. Robinson, I'm going to set your bond in the amount of $1,000. The conditions of your bond, sir, even while you're in custody, you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Okay.
Sorry, was that a yes?
Yes.
All right, that means that not only can you not live with her, you cannot call her, text her, email, social media, have a family member or friend send a message to her, or any other means of communication that I have not said. Understand?
He answered in the affirmative, Judge.
Okay, thank you. You also cannot possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature. Do you understand?
Yes.
I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else on Mr. Robinson's case that we need to address?
Nothing else, Judge.
Good luck to you, sir. Next is Mr. Quintana Izquierdo on page 9. All right, sir, good morning. I do find probable cause. Count 1, aggravated assault with a deadly weapon, domestic violence. Count 2, touch or strike battery, domestic violence. Count 3, resisting an officer without violence. Counts 4 and 5. 4 is a signed warrant that you're being held no bond on. 5 is a 94806 violation that you're going to be held no bond on. So with regards to 1, 2, and 3, Mr. Linder, first to you.
Judge, I'm recommending a $10,000 bond on the aggravated assault, a $2,500 bond on the domestic violence battery. Your Honor, just based on the charges that he's on probation for, specifically battery on a law enforcement officer, there is the potential that that charge could get upfiled to a felony battery. Should he postpone and be eligible for release, we're requesting pretrial release of the GPS monitor level 2 based on the alleged threats to kill. Your Honor, we'd also be asking for an order of random testing based on the specific allegations in the report, obviously with an order of no victim contact. Your Honor, Mr. Quintana Izquierdo was also arrested in 2015 for domestic violence battery by strangulation and domestic violence battery against the same alleged victim. Those charges were dropped. My office had contact with the alleged victim this morning. She did voice concerns for mental health issues. We advised her because of the no bond holds, while the public defender may be asking for a screen, there's nothing really that the court can order as far as treatment this morning, but we will make note of it so our office can advise his assigned judge at a later date, should that become relevant.
Okay, thank you. Mr. Romero?
Judge, I spoke Mr. Quintana. He had a lot to say. My understanding, Judge, is he is denying these allegations. He's looking forward to having his day in court and disputing these. My understanding also is, I believe in speaking Mr. Quintana, I do not believe the victim at the end is going to want to see Mr. Quintana prosecuted or be incarcerated. Having said that, Judge, he's been here his whole entire life. He's self-employed. He does construction for a living. Judge, at this time, considering he has no holds, what we're asking the court to consider is a total of a $2,000 bond on the new law offenses. I did advise him he's going to have to go in front of his division judge to seek some sort of relief on his VOPs. He is aware that this court cannot do anything on his VOPs. We're going to be asking to be provisionally appointed on his case, Judge.
All right, thank you. Based on the threats to kill, the court does take threats to kill very seriously. So on count 1, I am going to set bond in the amount of $10,000. Based on that, the prior battery Leo conviction, this could be elevated to a felony battery based on prior, sir. So I am going to set bond on count 2 at $2,500. Once you post bond, you're going to be supervised by pretrial release level 2 with a GPS. If your division judge gives you release on the no bond holds, you cannot have any contact with the listed victim, direct or indirect, even while you're in custody. Do you understand?
Yes, Your Honor.
That means no phone calls, no letters, no having a family member or friend send a message to her or any other means of communications that I have not said. Do you understand?
Yes, Your Honor.
You also cannot possess any firearms, weapons, or ammunition while your case is pending, and that includes knives. Do you understand?
Yes, Your Honor.
Okay, and I also am going to order no drugs or alcohol while your case is pending, and you're going to be randomly screened at least 2 times per week if your division judge gives you release. Do you understand?
Yes, Your Honor.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else in his case, Mr. Romero? Do you want a mental health screen?
No, Judge, not at this time.
Okay, thank you. Good luck to you, sir. All right, next is Mr. Corden. The listed victim is outside, so just give me 1 minute. Can you confirm that that's her name? It's not in the report, Mr. Linder. When we get her name, can you confirm it is her? It's not in the report. Yeah.
Yes, Your Honor, what I can advise the court, and I don't know if it's been put into Odyssey yet, because of the recency, I did speak with Officer Rodriguez this morning, and he provided me with the case number, like that.
Okay, so what's the case number?
DVCE 21-4375-63.
Couldn't find it.
I can also reach out to him, Your Honor, to get the name of the protected party.
Okay, I see it in the petition, and let me, that's the name I have here. All right, ma'am, good morning. You are the listed victim, and your name? All right, ma'am, are you here to see what happens, or did you want to tell me something?
I want you to something about my son.
Okay, so please raise your right hand for me, please. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes.
Okay, thank you. You can put your hand down, and now that you are sworn, you can state your name for the record again. All right, Ms. Citro, you were here without an attorney, and you previously spoke to law enforcement, so I need to advise you that anything you say today can be used against you at a later date. Do you understand?
Yes, yes.
All right, ma'am, what is it that you wanted to tell me?
I wanted to tell you that my son is mentally ill. I filed what have been
Judge, we can't hear anything.
She's soft-spoken. Yes, you're soft-spoken. If you could please just speak up. Hear you?
Okay. Okay. I am here to say that my son is mentally ill. He's followed by a psychiatrist. He's bipolar, ADD, OCD. He's a danger to himself. I have filed an act. The first part was taken from jail to an evaluation, and then I filed a second part for him to go to a long treatment, long rehab, because he is ill. He just came out from prison on January 30th. That was his birthday. He was good for 2 months. Then he was still okay until the end of May because we had a curfew until 10 p.m. And then in June, when he was free, it went down the drain, and he went back to between the prescription drugs, alcohol, and other drugs. He's a total mess. My son needs help. Senior citizen. This is my last chance. I've been doing this for 20 years. He's my only son, and he's got to be taken care of. He cannot be released. He needs help. He needs long-term rehab, psychiatry, psychology. He's deeply hurt inside. Something is very wrong with him.
Okay, thank you, ma'am. Mr. Linder or Mr. Romero, do you have any questions for the listed victim?
Not at this time, Judge.
No, Judge.
Okay, thank you. Thank you for being here. You can stay right there, and then while we go through with the proceedings. Okay. Okay, thank you. Mr. Linder, first you.
Your Honor, and I certainly understand everything that Mr. Kokordan's mother is advising the court. But that being said, because I don't know some of the things she mentioned about him getting certain types of assistance, I don't know that those things can happen immediately upon his release. So there is concern of what his bond and release conditions will be. Your Honor, I'm recommending a $7,500 bond on the violation of injunction. I'm asking that the bond on the Alpraz line be kept in place. Pretrial release with a GPS monitor at level 2. No victim contact, no return. Your Honor, the case that you were advised of, that he was just released from prison this year, it's a 2017 burglary of a dwelling with a battery, false imprisonment, carjacking, strong arm robbery, burglary of a dwelling, felony battery due to prior convictions, and petty theft. That was against an ex-girlfriend. I reviewed the probable cause affidavit this morning. He originally was sentenced to 5 years probation as a habitual offender. He violated his probation, and in December of 2019 was sentenced to 2 years state prison. Hence his release from Florida State Prison late January this year. Nothing further.
Mr. Romero.
Judge, since he's been released, he's been working at a restaurant. My understanding is, speaking Mr. Kokordin, that job and opportunity is still available to him. I believe it's an uncle. Now, he's been residing in South Florida for 20 years. He will have to find a separate place where to reside. But unfortunately, when he was arrested, he didn't have his wallet with him. He doesn't have anyone to post his monetary bonds. He doesn't have the funds to post his own monetary bond. He has no one to contact, Judge. He's asking to be released or to pretrial.
All right, thank you. That is not an appropriate request based on these allegations and the very serious crimes he just was released from Florida State Prison on. All right, so I am going to set bond on count 2, the injunction at $10,000. I'm leaving the bond in place on count 1, the alprazolam. Once he posts bond, he's going to be supervised by pretrial release level 2 with a GPS. You are also going to be randomly screened for drugs and alcohol at least 2 times per week. That means that you cannot use any drugs and you cannot use any alcohol while your case is pending. Do you understand?
Nice. Yes.
You also cannot return to the listed victims, your mother's home. Do you understand?
Yes.
You cannot have any contact, direct or indirect, with her. And do you understand, sir?
Yes.
That means not only can you not go by where she's living, you cannot call her, you cannot text her. No emails, no letters, no social media, no having a family member or friend send a message to her for you. Understood?
Yes, ma'am.
Or any other means of communication that I have not said. Understood?
Yes.
You cannot possess any firearms, weapons, or ammunition while your case is pending based on domestic violence nature. Do you understand?
Yes, ma'am.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Is there anything else on his case that we need to address?
No, Judge.
All right, good luck to you, sir. Good luck to you, ma'am. Thank you for being here. The random screenings, we hope will help him get clean, okay? Thank you for being here, Ms. Citro. All right, next is Mr. Montina on page 9.
Next to me, Judge.
All right, thank you. Good morning, sir. I do find probable cause for domestic battery by strangulation, dating relationship. It's a filed case. Mr. Linder, first to you.
1 moment, Your Honor. Your Honor, I can advise the court that on June 8th of this year, actually late May of this year, the alleged victim sought and obtained an injunction, order of protection. It is in place until September 24th of this year as a temporary injunction. I'm recommending a $10,000 bond and no victim contact based on the allegation that the alleged victim lost consciousness during this incident. I'm not showing any history, Judge, nothing further.
Okay, thank you. Mr. Romero.
Judge, my understanding is, being Mr. Montina, he's been residing here his whole life. He works at a car wash, only making $70 a day. Now, my understanding, I believe the date of incident on what we're here for was earlier this year. My understanding is the injunction, as the state advised us, was sought and obtained in May. Since then, he's abided by that no contact order. He's had no contact with the alleged victim. He will continue to not have any contact with the alleged victim. My understanding, Judge, he really doesn't have $10,000 to help, or anyone that has that sufficient amount of money to help him post a monetary bond. My understanding, Judge, he has a limited criminal history, but we were going to be asking, based on his evidence by him not having any contact order and not having any contact, him being able to abide by that no contact order, we're going to be requesting a $3,500 bond on Mr. Martinez's behalf for him to be provisionally appointed.
All All right, thank you. The allegations are that there were allegedly at least 3 separate incidents where he put the victim, choked the victim, one chokehold, and then another alleged 2 hands around his neck, and then another chokehold. And that second chokehold is the one where she allegedly passed out. When she did regain consciousness, it's alleged there was a struggle over a firearm that discharged inside the home. So I do find the state's request to be more than reasonable. I am setting bond in the amount of $10,000. The conditions of your bond, sir, you cannot have any contact, direct or indirect, with the listed victim, even while you are in custody. Do you understand?
Yes.
That means that not only can you not live with her, you cannot call her, text her, email, social media, have a family member or friend send her a message, or any other means of communications that I have not said. Do you understand?
Yes.
And I will also order that you not possess any firearms, weapons, or ammunition while your case is pending based on the domestic violence nature and the alleged threat to kill. Do you understand?
Yes.
I will permanently appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else on his case we need to address?
No, Judge.
Nothing else at this time, Judge.
Good luck to you, sir. We have one more domestic violence case, and we're going to take the Spanish interpreter cases. All right, last for the DV cases is Mr. Coleman on page 10. I have to sign them there, sorry. All right, Mr. Coleman, good morning. I do find probable cause, count 1, domestic battery by strangulation, dating relationship, count 2, touch or strike battery, dating violence, count 3, carjacking without a firearm or weapon. Mr. Linder, first to you.
Your Honor, I'm recommending a $10,000 bond on count 1, $1,000 bond on count 2, a $15,000 bond on count 3, pretrial release with a GPS monitor level 2, no victim contact. It's based not only on the allegations in this case, but Your Honor, I'm showing that Mr. Coleman has a pending felony from 2018 out of Leon County for armed burglary of a dwelling or structure or conveyance and grand theft of a firearm. He also has from 2016 out of Leon County, resisting without violence, false ID to law enforcement, nothing further.
Thank you, Mr. Romero.
Judge, and speaking of Mr. Coleman, he's a lifelong resident of Florida. He works in construction. Besides doing that, he's an aspiring musician and doesn't get paid very much. Now, my understanding, Judge, in speaking to him, in reference to count 3, my understanding in speaking to him, it is his vehicle. It may not be registered under his name. However, he's the one that purchased it, and they've been together for quite a number of years. My understanding, Judge, he is looking forward to contesting these allegations. He can live with his mother. His mother is the only person that can post his monetary bond. She works as a telephone receptionist. I'm not going to be able to afford anywhere close to what the state is asking for. Right now, he's also raising 2 kids. His 2 kids are with his mom. The alleged victim is not the mother of his 2 kids, Judge. So he needs to be out there in order to go ahead and help provide for the financial well-being of his children. We were going to be requesting a total of $15,000 bond on Mr. Coleman's behalf with free trial and to be provisionally appointed.
All right, thank you. I will note that the listed victim allegedly advised officers multiple times that there is a significant history of domestic violence between the 2 parties. Mr. Linder, did the state request pretrial in this case?
Yes, with GPS.
Okay, thank you. Okay, that's what I thought. All right, so I am going to impose bond as requested by the state. Count 1, $10,000, count 2, $1,000, count 3, $15,000. Once he posts bond, if he's able to do so, he's going to be on pretrial release level 2 with a GPS, so he can still work, but but based on the very serious allegations, he's going to be on that pretrial monitor. The conditions of your bond, even while you're in custody, Mr. Coleman, you cannot have any contact, direct or indirect, with the listed victim. Do you understand? Okay, that means that not only can you not live with her, you cannot call her, text her, email, social media, have a family member or friend send a message to her, or any other means of communication I have not said. Understood, sir?
Yes, Your Honor.
Speak up. Yes, ma'am.
Thank you, sir. You also cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes, Your Honor.
Okay, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else on his case that we need to address?
No, Judge.
I think that Mr. Coleman was advised me because of his work schedule is flexible. We understand the court made a ruling as far as level 2 with the monitor. Would the court consider an open schedule?
Mr. Linder, state.
Your Honor, considering he's already out on a punishable by life offense and now a first degree felony involving violence, then level 2 would be appropriate.
All right, thank you. Based on those reasons, I tend to agree with the state. He has a pending armed burglary that's punishable by life and from another county. So that's more than reasonable. Good luck to you, sir. I cannot revoke that bond in Leon County, but that doesn't mean they cannot revoke it on their own. All right, we do have a Spanish interpreter here, Mr. Rojas. Good morning, sir. Thank you for your patience. All right, on page 12, let me swear you in. Sorry about that. Do you swear or affirm to translate from Spanish to English and English to Spanish to the best of your ability?
I do.
All right, thank you. First is Mr. Lovano on page 12.
He's here, present, Judge Amain.
All right, thank you. Good morning, sir. I do find probable cause for petty theft, second degree, first offense.
Buenos días, señor. Considero posición usual de delito para el delito de furto menor en segundo grado, primera incidencia.
Mr. Linder, first to you.
Señor Linder.
One moment, Your Honor.
Your Honor, can you get the arrest number or case number?
Yes, of course. It's 5921000349. His first name is Peter.
Okay, thank you.
Okay, thank you, Your Honor. If Mr. Lovano wishes to resolve the case, the offer would be a withholding court costs, no return.
El señor Lona desea resolver este caso, la oferta sería en pago de condena y costos judiciales con la prohibición de regresar al sitio de los hechos.
He has prior, so I don't know if he'd be eligible for diversion, but it appears this would be his first step.
Could you repeat that, Mr. Luna?
He has priors, so I do not know if he would be eligible for a diversion program.
Tiene antecedentes, así que no sé si sería elegible para el programa alterno.
But this would be his first step.
Pero este sería el primer paso para hacerlo, si lo fuera.
Judge. Judge, I did speak to Mr. Lovano. I believe this area or this place involves a Walgreens. Regardless of what happens, he does understand no return to the Walgreens.
Señora juez, sí, que este incidente tiene que ver con un Walgreens, independiente de lo que pase, él entiende que puede regresar a ese Walgreens.
Judge, I believe his priors in speaking to Mr. Lovano are nothing similar in nature. I believe may potentially possession of cannabis offenses. He works in security. Because this involves a theft case, I'm going to be asking the court an ROR on his behalf.
Creo que el señor tiene antecedentes a los que posiblemente una posesión de cannabis. Dado el hecho de que trabaja, voy a solicitar que sea puesto en libertad bajo libertad condicional.
Does your office need to be appointed?
Judge.
Ya que decide su oficina.
Do you have his phone number?
¿Tiene el número de teléfono?
I do, Judge. That's my father's. Oh, what's yours? 754. Okay, I thought that was yours. The screen cut off. Something happened.
The whole system just went down.
I know it's the judges that cut off because the interpreter is still moving. Okay.
All right, let's try this again. The system just froze.
Oh.
All right, so do you have his phone number, Mr. Romero?
He's getting it as we speaking.
All right, sir, I'm going to release you on your own recognizance.
Bien, señor, voy a dejar en libertad bajo palabra.
But you cannot return to the Walgreens and the police reports. Do you understand?
Pero le queda prohibido regresar
regresar a Walgreens que se menciona en la policial, ¿entiende?
En voz alta, sí.
Yes.
Yes.
And it will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply.
Y voy a designar a la oficina de los defensores públicos para que lo representen. Y una vez que pase la pandemia COVID, tiene que nuevamente la
Anything else in this case?
¿Alguna otra cosa?
En este caso,
No, Judge.
No, señora juez.
no, señora juez.
Tú estás en los números del defensor público. Cuando sales para hablar con tu abogado, este número llamas, ¿ya?
Our next Spanish interpreter case at Maine is Mr. Lopez on page 22. First name is Marben, Mr. Rojas, and his number is 5821000201.
Thank you, Your Honor.
You're welcome. Oh, it looks like they froze again.
I can't hear anything.
By the way, Your Honor, it's very difficult to hear Mr. Romero from where I am.
We're going to
Reset the
shut down again. We're going to be back on the regular system tomorrow. It's because we had technical issues all week that we're on.
All right.
We're going
Oh,
to.
shoot, your microphone off. That's why we couldn't hear.
Okay, so we shut down again. So hopefully we're back up now. Okay, so this is on Mr. Lopez on page 22 then.
Señor López, página 22.
Okay, I do find probable cause for possession of cocaine and trespass.
Siendo que existen indicios probables para los delitos de posesión de cocaína y entrada ilegal en una propiedad.
Mr. Linder, first to you, please.
Señor Leder, primero usted, por favor.
Your Honor, recommending him ROR to pretrial random testing.
Habrá medidas cautelares y pruebas sin aviso de sustancias.
No objection, Judge.
No hay objeción.
I'm going to be asking to be provisionally appointed, and I do have his phone number.
Solicitamos
His phone number is 54422-8766.
What were the first three?
754
It broke up again.
754
754. Okay, did you get them, Ms. Worrell?
Yes, Your Honor.
All right, sir, you cannot use any drugs or alcohol while your case is pending because you are going to be randomly screened while your case is pending. Do you understand?
A usted se le prohíbe usar drogas o
¿Sí me entiendes?
Sí.
You also cannot return to the restaurant and the police reports. Do you understand?
Tampoco puede
regresar al restaurante que necesita los informes policiales, ¿entiende?
¿Entiendes? Más alto.
Okay, and I will provisionally appoint the Office of the Public Defender.
During the pandemic, sir, once COVID is over, you will need to reapply to make sure they keep representing you.
Y si voy a designar provisionalmente a la oficina de defensores públicos para representarlo, señor, una vez que termine la pandemia, tendrá que presentar nuevamente la solicitud para que lo represente.
All right, good luck to you, sir. You're going to be released a pretrial release and you need to call in tomorrow morning before 11 a.m.
Buena suerte, señor, que han libertado bajo medidas cautelares. Tienen que reportarse con la oficina de medidas cautelares a más tardar mañana a las 11 de la mañana.
Anything else on his case?
¿Alguna otra cosa en este caso?
Okay, thank you.
Bien, gracias.
So that's it for main jail. Mr. Farberic, we did not have any interpreter cases at any of the other jails, correct? Okay, thank you. Thank you so much, Mr. Rojas. Have a great day. Okay, so we just finished our DV cases, so that brings us to page 11. Mr. Alvarado.
Mr. Joseph Alvarado, come on up, please.
All right, Mr. Alvarado, good morning. Mr. Linder and Mr. Farberic, is there any legal objection why I cannot find probable cause for aggravated battery deadly weapon? It's alleged the victim was stabbed in the hand.
No, Judge.
Yes. You're muted. You're muted.
Judge, there's no indication. It just indicates that she was stabbed. It doesn't indicate what the weapon, or if it was a weapon, or if it was a fingernail, or it says unknown weapon, but it doesn't specify. And it doesn't say anything with regards to the injury other than a scratch. So I would object to the court finding aggravated battery.
Actually, it says a fresh scratch on the victim's neck and a fresh cut on her left hand where it indicates she was stabbed. So over the defense's objection, count one, I do find probable cause for aggravated battery, deadly weapon. Count two, an out-of-county hold from Hendry County that you're being held no bond on, that I have no jurisdiction over. With regards to count one, Mr. Linder, first to you.
Judge, I'm recommending a $5,000 bond, no victim contact, no possession of any weapons. Your Honor, this is based not only on the court's finding made this morning, but additionally, in the alternative, this matter could be potentially upfiled to a felony battery due to priors, be it a 2007 battery. He also had 2008 burglary of a dwelling and theft. He violated probation, was sentenced to just over 34 months state prison. 2009 grand theft, same sentence. Also noting, it would appear that he failed to appear in court in another county, and that's why he has a no bond hold.
Thank you, Mr. Romero.
Judge, I spoke to Mr. Alvarado. He's disputing the allegations or the findings that the court made. I did advise him right now. He'll have his day in court to present an evidentiary a motion. But my understanding is the alleged victim, basically the injuries that are in her hand as a result of self-injecting. She's a drug user. Let me do the talking. You don't do the talking. She's a drug user, and that's how she uses an injection to get the drugs into her system. I believe that's what the officer suspected, and that's why he didn't charge her with the felony and just charge her as a misdemeanor battery. So for mitigation purposes, Judge, I do realize he has a no bond hold. There's nothing the court can do. He has to wait till that county comes and picks him up, but I was going to be asking for the court just to leave the standard bond in place.
All right, thank you. So I'm going to set bond in the amount of $3,000 on the aggravated battery. The conditions of your bond, even while you're in custody, sir, you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Yeah.
That means that not only can you not call her, you cannot send her letters, email, to social media, have a family member or friend send a message to her, or any other means of communication I have not said. Understood? You also cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes.
All right, good luck to you, sir. You'll also have to go to Hendry County to answer to that out-of-county hold. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic on count one. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else on his case? All right, good luck to you, sir. Next is Mr. Cleary on page 11.
He's approaching, Judge. Me?
All right, thank you. All right, Mr. Cleary, good morning. I do find probable cause for trespass. Mr. Linder, does the state have an office?
No, Your Honor, I'm gonna ask that the court transfer this case to Judge Lineren's MI division with an order of no return. I checked, Mr. Cleary has at least one pending case in mental health at the moment.
Okay, thank you, Mr. Romero.
Judge, my understanding is, in speaking to Mr. Cleary, he doesn't have much contact with the criminal justice system from what he advised. He is homeless. I did ask him as far as the nature of these allegations. My understanding, he has no prior convictions on his record. We were going to be asking for the court to consider an ROR on Mr. Cleary's behalf.
What about the state's request to send him to mental health court because he has another pending case there?
Let me ask. One moment.
Thank you.
Yeah, I also further advise the court, Mr. Perry was released in division to pretrial standard. He was released out of pretrial standard supervision May 11th of 2020, and he have not reported in any way, shape, or form for his intake. This morning, when I noticed it, I advised the pretrial officer that the case is assigned to that a warrant was done, so a warrant went over to Lorna Rain this morning for signature.
Okay, thank you.
Judge, we didn't hear anything what pretrial was advising the court.
He was advising me that pretrial submitted a warrant this morning to his division judge, Judge Lerner Wren, based on not only this new arrest, but the allegation that he never reported when he was released on May 11th of 2020.
Do you know what was the charge on the case that he's currently out on supervision?
Trespass property. Hold on.
She's looking.
It looks like his pending case is before Judge Lorena are trespasses.
Other trespasses.
Yes.
He's got more than one. All right, so I will leave the bond in place and transfer this case as well to Judge Lerner Wren's mental health court with an order of no return. I will provisionally appoint the Office of the Public Defender to represent him during the pandemic. Once COVID is over, he'll need to reapply if this case is still pending. Good luck to you, Mr. Clary. Next is Mr. Kimball on page 11.
Judge, he bonded?
All right, thank you. I do find probable cause for his KPS for petty theft. For the record. Okay, next is on page 12, Mr. Voos, how do you say your name, sir?
Voos, ma'am.
All right, Voos, sorry about that. All right, I do find probable cause for trespass. Mr. Linder, does the state have an offer?
Your Honor, I do. The offer's an adjudication, 5 days in Broward County Jail, no return. And Your Honor, while I normally don't make jail offers on these type of charges, Mr. Voos is just causing disturbances to this business, to the owners of this business, to the patrons, the patrons of this business. And the owner of this business has a right to conduct his business without being disturbed. Your Honor, as mentioned in the report, Mr. Voos was just trespassing this location July 7th. He was then arrested July 10th, and he pled out at first appearance to time served. He was also arrested January 25th of this year at this same location in trespass one. I'm noting in this PC affidavit, it wasn't just a matter of him standing around and being somewhere where he wasn't supposed to be. He was causing a disturbance. He's had this is his 8th arrest in the past year and a half, 21 in the past 10 years, Judge.
Thank you, Mr. Rivera.
Judge, thank you. My understanding, Judge, he is homeless. No one's going to be able to afford to post his monetary bond, Judge. He did advise me that in exchange for his no contest plea and giving up his right to have a trial, he would like to invite the court into plea negotiations. Ask if the court would consider extending an offer of time served. This is a trespass, Judge. He is giving his right to dispute these charges. He is taking responsibility. But he's asking if the court would consider extending an offer of time served.
I will not actually get involved. I'm not going to do any better than the state's offer.
Let me talk to him, Judge.
All right, thank you.
Already what, about 2 days in?
Judge, at this time, he wishes them to accept the state's offer.
All right, thank you. Sir, please raise your right hand for me to the best of your ability. Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, thank you. You can put your hand down and please state your name for the record.
D'Angelo Booth.
All right, sir, my understanding that you wish to resolve this trespass case, correct?
Yes, ma'am.
And do you understand the charge against you?
Yes, ma'am.
Do you understand everything that's happened here today?
Yes, ma'am.
Is anyone forcing you to resolve this case?
No, ma'am.
Are you under the influence of alcohol or drugs?
No, ma'am.
And do you need more time to speak to your attorney?
No, ma'am.
And do you understand you have a right to go to trial and fight this charge, but you're forever giving that up by accepting the state's offer?
Yes, yes, ma'am, because well, you know what? Yes.
And have you ever been treated for a mental or emotional illness?
Yes, I have. Bipolar, schizophrenic, schizophrenical.
Okay, and is there anything about that illness today that impacts your ability to accept this plea?
No, ma'am.
And you understood everything that's happened so far?
Yes, ma'am.
All right, and how do you wish to plead, sir? Guilty or no contest?
Contest.
All right, sir, accept your no contest plea is freely, voluntarily, knowingly given. I also find there's a factual basis for this plea based on the probable cause affidavit. I am going to sentence you to an adjudication of 5 days in the Broward County Jail with an order of no return once you get out. And how much time does he need to pay?
Judge, we're going to be asking for a civil lien.
All right, and I'll convert your court cost of prosecution, PD application fee to a civil lien. What that means, sir, is that it's a civil judgment that's good against you for 20 years. If you ever do come into the money, you'd have to pay that off. Good luck to you, sir, after your 5-day sentence with all your credit for time served. You will be released. How many days in does he have? 2?
Judge, we just put 5 days Broward County Jail with credit time served, and we'll calculate the credit. He'll get 1 day and he'll be released on the 17th.
Okay, thank you. All right, good luck to you, sir. All right, next is Mr. Morales on page 12.
He's approaching Judge Maine.
All right, thank you. Mr. Morales, good morning, sir. I do find probable cause for petty theft, first degree, property over 100, less than 750. I do note it is a listed victim, not a business. So Mr. Linder, what's the state's recommendation as to bond?
Your Honor, I spoke with Mr. Hoover this morning. I'm going to be recommending that he be Mr. Morales be transferred to Judge Lineren's Mental Health Division. I can see we ran his CCIS. He's on 3 prior occasions. He's been ordered to mental health treatment out of Palm Beach County. Mr. Hoover would have no objection to the court transferring the case to mental health. He actually would support that because he does believe Mr. Morales, based on what law enforcement advised him, he does believe Mr. Morales needs some assistance, Your Honor. He would be opposing just a straight time served order because he believes that more is appropriate here, as he's been advised that there's been issues with Mr. Morales in the neighborhood, that his bike was taken from his property. He also thinks he may want to address the court at a future date. So under Marcy's law, it's another reason I'm unable to make an offer at this time, Your Honor. I can advise the court, Mr. Morales was just arrested July 2nd of this year in Hollywood at East Young Circle. He was ROR'd at his first appearance. So I'd ask that the court keep the bond in place with an order of no victim contact, no return, and a transfer to MI division. Nothing further.
Thank you. Mr. Romero?
For Mr. Morales, I do have severe mental health concerns. I'm going to be asking for mental health screening. He is homeless. He can't afford a bond. I'm going to be asking for this case to be transferred to Judge Lerner. Obviously, Judge, at this time, since it's nonviolent, I am going to be requesting an ROR, but I do understand where the court's coming from if the court wanted to leave the bond in place.
All right, I am going to leave the bond in place with a transfer to mental health court. This was allegedly taken from a victim. So instead, it's not a business crime. The crime is a person. So I will sign that mental health screen, and I will provisionally appoint the Office of the Public Defender to represent him during the pandemic. Once COVID is over, he'll have to reapply to make sure they keep representing him. I am going to order no return to the incident location and no contact, direct or indirect, with the listed victim. Mr. Morales, direct or indirect, no letters, no phone calls, no having a family member or friend send a message or any other means of communication, even if you don't know the listed victim. Okay, good luck to you, Mr. Morales. We're going to get you a doctor to talk to, sir. All right, next is Mr. Franco on page 12.
He's a refusal, no legal objection, Judge.
All right, thank you. We're proceeding. These are out of county holds for child support from 2 separate counties. He has Lee County child support in the amount of $376 and Charlotte County child support in the amount of $365. He needs to pay both of those purges to be released. Next is Mr. Joe on page 12, who waived.
Correct.
All right, thank you. I find probable cause for his out-of-county hold from Kendry County for reckless driving. He's being held no bond and for a failure to appear. Anything else on Mr. Joe?
No, Judge.
Okay, thank you. That brings us to page 13. Mr. Valdez Roman has bonded. For the record,
Sorry.
Mr. Valdez Roman has bonded. I do find probable cause for driving under the influence of alcohol or drugs, second offense, refusing to submit, operating without a valid DL, and driving with license suspended. Next is Mr. Simmons on page 13.
He's here, present judge, right next to me.
All right, thank you. I do find probable cause for resisting an officer with violence. Any legal objection based on the allegations that he headbutted the officer?
I'm sorry, I was just saying the resisting with violence, it's the statute specifically states offering violence, it doesn't have to make contact.
Correct. He tried to, but the officer stopped him mid headbutt.
That's okay.
All right, thank you. Without objection, I do find probable cause for resisting an officer with violence. So Mr. Linder, first to you.
Judge, I'm recommending $1,000 bond. I'm showing that Mr. Simons is, he has a pending 2017 case for battery on a law enforcement officer resisting with violence, 2 counts of DUI property damage, 1 count of DUI. He also had a 2019 resisting without violence, trespass and disorderly intoxication.
What year was that pending, that Leo?
2017, Your Honor, and I believe it's before Judge Merrigan in Veterans Court.
Okay, thank you. All right, thank you. Mr. Romero?
Judge, and speaking of Mr. Simons, he is working, he has a place to stay. He lives in Hallandale, Judge. More importantly, from what he advised me, there's no one that's going to be able to post his monetary bond. Judge, we were going to be asking for the court to consider releasing him. Our award of pretrial. He will be coming back to court to face these allegations, Judge.
All right, thank you. He's not a candidate for a straight pretrial because of the pending charges of a similar nature. I am going to set bond in the amount of $1,000. Once you do post bond, you are going to be supervised by pretrial, though, because the alcohol influence box is checked off, sir. That means that you cannot use drugs and you cannot use alcohol while your case is pending. Do you understand?
Yes.
You are also going to be randomly screened for drugs and alcohol while your case is pending. And Mr. Romero, does your office need to be appointed?
Yes, Judge.
All right, thank you. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else on his case?
No, Judge.
Good luck to you, sir. Next, Mr. Benitez on page 13 is a first-time refusal because it is not a crime of violence. He's being reset one time as a courtesy. Next is Mr. Spear on page 14.
He's approaching, Judge.
How you doing, Your Honor?
Okay, thank you. I'm fine. Thanks for asking. I do find probable cause. You have 2 capiases, leaving the scene of an accident and operating without a valid driver's license. Your bonds are $1,500 and $500. I will provisionally appoint the Office of the Public Defender to represent you during the pandemic on both of these cases, bringing them here from the satellite division. So you'll have to file a motion with your division judge based on the leaving the scene. I don't believe there's an offer today, correct, Mr. Linder?
Correct, Judge.
Okay, so anything else on his case we need to address?
Yes. My understanding, speaking with Mr. Spear, he advised me basically in the beginning of July, he suffered a motorcycle accident and he was hospitalized for 7 days. He advised me that is the reason why he missed court. It wasn't that he willfully missed court. He's asking based on that if the court would consider releasing him on pretrial release today.
Give me 1 minute. What was the date?
He advised me he suffered the accident July 1st and he was hospitalized for 7 days.
Okay, you missed court on June 26th, so that will be denied. Good luck to you, sir.
Judge, would you sign a phone order?
I will. All right, let me add that in there, phone order. All right, not a problem. Next on page 15. Mr. Mustafa.
Is Mustafa back or is he still in?
We put him towards the end.
Still in court.
Okay, we'll come back to him. Thank you. All right, next, I just was hoping he'd be back. No problem. Next on page 16, Mr. Mays.
The approaching judge here at Maine.
Okay, thank you. Mr. Mays, good morning, sir. I do find probable cause for robbery by sudden snatching without a firearm or weapon. Count 2 is a pretrial warrant that you're being held no bond on that I have no control over. So with regards to count 1, Mr. Linder, first to you.
Judge, I'm recommending a $7,500 bond pretrial release of the GPS monitor level 2, no victim contact. Your Honor, while I certainly recognize that he was on pretrial already and violated, my concern is that there was appears to be a relationship between the two parties in the robbery. Mr. Mays in 2002 had a kidnapping with 3 counts of sexual battery, 2 counts with using great force or weapon. He was sentenced to 11 years in state prison. It would appear that he is a registered offender, Your Honor. He also has another pending possession of substituted cathinones in addition to the case that he's being held no bond on. Nothing further at this time.
Okay, thank you. Mr. Romero?
Judge, Mr. Mays is working. He's employed at a car wash, only making about $75 a day. Based on his financial resources, Judge, this is a 3rd-degree felony. I'm asking for the court to consider a $2,500 bond on count 1 and to provisionally appoint our office.
All right, thank you. I do find it aggravating. It's alleged that he took the phone from the listed victim while she was on the phone with police. I don't know what led up to that, but that does give the court concern for her safety. Also, the allegations that he was previously convicted of kidnapping and 3 counts of sexual battery, for which he served 11 years in Florida State Prison, which I am taking into consideration. I am going to set bond in the amount of $7,500. Once he posts that bond, he's going to be supervised by pretrial release level 2 with a GPS, finding it necessary to protect the listed community from Mr. Mays. Sir, even while you're in custody, the conditions of your bond and release are that you cannot have any contact, direct or indirect, with the listed victim, your ex-girlfriend. Do you understand? That means that not only can you not call her, you cannot send letters, you cannot have a family member or friend send a message or any other means of communication that I have not said. Do you understand? Is that a yes? All right, also based on the relationship between the parties, you cannot possess any firearms, weapons, or ammunition while your case is pending. Understood? He's soft-spoken.
Yes, ma'am.
All right, sir, and I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you will need to reapply to make sure they keep representing you. Good luck to you, Mr. Mays. All right, next is Musin on page 16.
That's your last name, sir?
She said it right.
Oh, she said, Judge, you're.
Oh, okay, thank you. Oh, good. I'm glad I got it. All right, sir, good morning. I do find probable cause possession of burglary tools with intent to use, false ID to Leo, loitering or prowling, and resisting without violence. Mr. Linder, first to you.
Judge, I'm asking that the court keep the bond in place with an order of no return. I'm showing Mr. Musin has a warrant right now out of the state of California from May 10th of this year for assault with a deadly weapon, great bodily injury likely, and contempt of court disobeying a court order. Nothing further.
Okay, thank you. Mr. Romero?
Judge, I believe if I heard this state correctly, they're asking for the bond to be remain in place at this time. No objection. We're going to be asking to be provisionally appointed.
Okay, thank you. All right, so I will leave the bond in place with an order of no return. Sir, do you understand?
Yes, ma'am.
All right, you can't go back to the alleged incident location, and it's $1,000 bond. Problem I'm having is that the drug influence box was checked off too. All right, so once you post bond, you're going to be supervised by pretrial release of the allegations that were allegedly at 3:55 in the morning. So you're going to be supervised by pretrial release once you post bond. You cannot use any drugs, you cannot use any alcohol, and you will be randomly screened for drugs and alcohol, sir. So once you post your bond, you have to call on the next business day before 11 a.m. Understood?
Yes, ma'am. Yes, ma'am.
Right, and I'm not sure if I said this, but I'll provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, sir, you'll need to reapply to make sure they keep representing you. Ms. Worrell, do you want his phone number now?
Go ahead.
All right, whenever you get a chance, please give a pretrial your phone number, sir.
Your phone number right now.
754-801-0835. That's my cell.
You got it?
You got it.
All right, good luck to you, sir.
Thank you.
All right, next is Mr. Summers on page 16.
He's approaching.
All right, good morning, sir. Do either of the parties have a legal objection to a dwelling? It's alleged this is the victim's fenced-in backyard.
No, Judge.
All right, without a legal objection, I am going to change it and make a finding that this is, I find probable cause for burglary of an occupied dwelling. Count 1, count 2, petty theft, second degree, first offense. Mr. Linder, first to you.
Showing a DUI 2016, possession of cocaine 06. Considering this was someone's home, Your Honor, I'm recommending a $10,000 bond. No victim contact, no return, nothing further.
Thank you, Mr. Romero.
Judge, my understanding, I haven't read the PC affidavit. I know Mr. Summers has advised me he's looking forward to having his day in court, but I believe this is basically jumping over the fence and going in the backyard and not making his way into a home or anyone making their way inside the home. Considering that, Judge, he's self-employed. He paints. He doesn't make very much money. He's been here his whole life. He lives in Deerfield. The last time he had contact with the criminal justice system was, I believe, several years ago. But as you've heard, nothing violent in nature and nothing similar in nature recently. Having said that, he's living in Deerfield with his mother. His mother's going to try and get the funds together to try and see if she can help post his monetary bond. We're going to be requesting a $2,500 bond on his behalf, Judge.
All right, thank you. And does your office need to be provisionally appointed?
Yes, Judge.
All right, thank you. So I will set bond in the amount of $7,500 on count 1 with an order of no return to the incident location. Do you understand?
Yes. Yes.
All right, you also cannot have any contact, direct or indirect, with the listed victims, sir. You may not know who they are, but you cannot call, send letters, have a family member or friend send a message, or any other means of communication that I have not said. Understood?
Yes, ma'am.
All right, I will also provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else on his case we need to address?
No,
No.
Judge.
Good luck to you, sir. Next is Mr. Bennett on page 17, who's refused, but there was no legal objection why we could not proceed.
Correct, Judge.
All right, thank you. I do find probable cause for possession of oxycodone and his probation violation that he's being held no bond on. Count 1, I'll leave the bond in place at $1,000, and I will provisionally appoint the Office of the Public Defender to represent him on both cases during the pandemic. Anything else on Mr. Bennett?
No,
Judge, can I have a mental health screening in the situation?
All right, no problem. I'll put that in the findings, mental health screen. All right, thank you. All right, next is Mr. Moreland on page 17. It's a big one, sorry. All right, Mr. Moreland, good morning. I do find probable cause for burglary of an occupied conveyance unarmed. Count 2 is a burglary of an unoccupied conveyance unarmed. Mr. Linder, first to you.
Judge, while I don't see a history, I'm recommending a $5,000 bond on the burglary of an occupied conveyance. I do have safety concerns based on the allegation that it would appear he consciously broke into a woman's car while she was sitting in the vehicle. On the unoccupied conveyance, I'd be recommending a $1,500 bond. No victim contact and no return on both counts.
Okay, thank you, Mr. Romero.
Mr. Moreland's been residing in our community his whole entire life. He just managed to get a job. He got employed with Advanced Auto Parts, only making $11 an hour, but unfortunately at this time he is homeless. He has no one to help post his monetary bond. He's asking if the court would consider releasing him ROR to pretrial, and we're asking to be provisionally appointed.
All right, thank you. Based on the allegations that the listed victim, one of the listed victims was in the front driver's seat when he allegedly entered her car, know that he's not a candidate for pretrial based on this randomness and these sets of allegations. I will set bond on count 1 at $5,000, on count 2 $1,000. Sir, the conditions of your bond are that you cannot return to the incident location, the Wawa, and the police reports. Do you understand?
Yes.
Not have any contact, direct or indirect, with either of the listed victims. Do you understand?
Yes, ma'am. A little louder. Yes, ma'am.
All right. Although you may not know them, sir, you cannot call, send letters, have a family member or friend send a message to them, or any other means of communications that I have not mentioned. Understood?
Ma'am.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, Mr. Moreland. Once COVID is over, you will need to reapply to make sure they keep representing you. Anything else in his case that we need to address?
Nothing else, Judge.
Good luck to you, Mr. Moreland. All right, next is Mr. Ellis on page 18.
Approaching Judge Main.
All right, thank you. Mr. Ellis, good morning, sir. I do find probable cause. Count 1, trafficking in oxycodone, 25 grams, but less than 100 grams. Count 2, possession with intent to sell or deliver alprazolam or Xanax. Count 3, possession with intent to sell or deliver amphetamines. Count 4, possession with intent to sell or deliver heroin. Count 5, possession with intent to sell or deliver cocaine. Count 6, possession with intent to sell or deliver amphetamine. Count 7, drug paraphernalia. Count 8, traffic infraction regarding driving on the wrong side of the road. Not for me. Count 9, possession with intent to sell or deliver fentanyl. Count 10, possession of weapon or ammunition by convicted felon, completely separate incident date, signed warrant regarding a shooting involving Mr. Ellis and Ms. Worrell. First to you, ma'am.
Be honest, the defendant is currently out on pre-trial in case number 213153 CFNA. Count 1, possession of a weapon or ammunition by convicted felon. Count 2, distribution or delivery of cocaine. Count 3, resisting officer without violence. This time we're going to request a revocation of the incident case. He also posted a total bond of $11,000. Bond on count 1 and 2 were set at $5,000 each. Bond on count 3 was set at $1,000.
Okay, thank you. So at this time, I am going to grant pretrial's request. He's going to be held no bond on 213153 CF10A. Charges are firearm by felon, delivery of cocaine, and resisting without violence. Mr. Linder, first to you on the other counts, sir. I know that the reports indicate he has a 2008 conviction for second-degree murder.
That's correct, Judge. Your Honor, I'm asking that the court keep all the bonds in place, including the bond that Judge Bailey set on the arrest warrant, noting that he also has a pending possession of firearm, unlawful possession of firearm offense that you just revoked his pretrial on. That is correct, Your Honor. And he had a 2007 murder in the second degree that he was convicted on. He violated probation. He was sentenced to 12 years in Florida State Prison. He was just released February 15th of last year. That is why, Your Honor, even though the court is revoking his pretrial, I do believe he poses a danger to the community if he is released under any circumstances. So should he be eligible for release on the trafficking case and or the firearm offense, I would also ask that he be again supervised by pretrial with a GPS monitor level 1, no possession of any firearms, weapons, or ammunition. Nothing further.
Thank you, Mr. Romero.
Judge, I understand the court revoked his release on the pending case. He's going to have to go in front of his division judge to seek some sort of relief. If he does manage to seek some sort of relief, he would like this court to address count number 1. There's no way he's going to be able to afford $500,000 bond. I believe the state wanted to have him supervised on level 1. We would have no objection with that, but we would ask also in exchange for level 1 if a bond reduction from $500,000 to $50,000. I know in speaking to Mr. Ellis, he did advise me. He is employed. He's a musician. Doesn't get paid all that much. So that's the basis of why we're requesting a bond reduction of $50,000 rather than $500,000.
All right, thank you. I understand your request. That will respectfully be denied, not only based on the prior murder conviction for which he was just released from Florida State Prison last year, but also his confession to being a drug dealer. I'm leaving the bonds in place with pretrial release level 1 with a GPS should he post bond, strict house lockdown. You cannot possess any firearms, weapons, or ammunition while your case is pending. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, Mr. Ellis. Once COVID is over, you will need to reapply to make sure they keep representing you. I will reduce however, count 7 and ROR because it's a drug paraphernalia. Good luck to you, sir. I'm sorry, ma'am?
Both cases has count 7 so AF warrant.
Yes, on both cases. On count 10, on that case as well, it's also pretrial release level 1 on all cases, all counts.
No firearms, weapons, or ammo.
Yep, I already said that too. Okay, so it's counts 1 through 7 and 9 through 10. All right, so that's for all counts, no firearms. Okay, so next on page 18 is Mr. Ruddock, who's refused, but we're proceeding without him. I do find probable cause for burglary of an unoccupied conveyance unarmed. Counts 2 and 3 are pretrial warrants. He's being held no bond on. So with regards to count 1, Mr. Linder, first to you.
Recommending a $1,500 bond, no victim contact, no return, Judge. And Ms. Cooper, does count 3 need to be deleted? Because it's one case with 2 counts, and I believe the THC was declined.
It's on Reddit?
Yes.
Yes, already updated on the vote on the possession of THC.
So what do you want to do on count 3, ROR?
No, it's not for magistrate anyway. You don't have to.
Okay, thank you. All right, Mr. Romero, did you need to be provisionally appointed?
Yes, Judge, we're just asking to be provisionally appointed, Mr. Roddick's behalf.
All right, thank you. So I don't know if you heard that, but count 3 was declined, the possession of THC, so that'll be removed on the sheriff's website. So you'll have to go before his division judge on count 2 still, okay?
Thank you.
All right, thank you. So on count 1, I will set bond in the amount of $1,500 with an order of no return, no victim contact, direct or indirect. And also I will provisionally appoint the Office of the Public Defender to represent him during the pandemic. Next is Mr. Rawls on page 19. All right, Mr. Rawls, good morning, sir.
Good morning.
Do you find probable cause for resisting without violence and possession of weapon or ammunition by a convicted felon? Mr. Linder, first to you, sir.
Judge, I'm recommending a $5,000 bond, no firearms, weapons, ammunition. His history, 2015, resisting without violence. 2012, felony battery due to prior convictions. 2011, aggravated assault with a deadly weapon and battery. 08, delivery of cocaine, possession of cocaine. 16 months state prison. 05, violation of a protective injunction order. 05, another violation of a domestic violence injunction. 3 possessions of cocaine between 98 and 02, and an escape in 2000. Nothing further.
Okay, thank you. Mr. Romero.
Judge, he's been residing here in our community his whole entire life. He is employed, been working for the same company for the past year. It's a company that I believe maintains the walls around I-95. He only gets paid about $12 an hour. He lives locally here in Pompano Beach where he rents, does not own. He's been living there in the same apartment for 4 years. He's a breadwinner, paying about $900 a month. His girlfriend is really not going to be able to afford to post a monetary bond. He's asking for the court to consider releasing him on pretrial release. As I heard correctly, he's had no recent contact with the criminal justice system. I believe it's been well over 5 years. So that is why we're requesting pretrial release and to be provisionally appointed.
All right, thank you. I understand your request, Mr. Romero. Respectfully, that's denied. The allegations are that he not only possessed a firearm, but there was a discharge where it's alleged he discharged the firearm during an altercation. So I am going to set bond on count 2, the firearm by felon at $5,000. Count 1, I'll leave in place. Sir, you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes, ma'am.
All right, I will also provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, you will need to reapply to make sure that they keep representing you. Understood?
No.
All right, anything else on his case that we need to address?
No, Judge.
Good luck to you, Mr. Rawls. Next is Mr. Harden on page 19.
Judge, if we could put that on brief recall, just is using the restroom.
Okay, no problem. Next is Mr. We'll come back. Next is on page 20, Mr. Bullock.
Mr. Beck, come on, please.
All right, Mr. Bullock, good morning. I do find probable cause for aggravated battery caused bodily harm or disability. Mr. Linder, first to you.
Your Honor, I'm recommending a $15,000 bond, no victim contact, based on the level of violence that he allegedly fractured the victim's orbital bone, and according to the probable cause affidavit, at the time it was authored, the victim was still unable to see out of his left eye.
Thank you, Mr. Romero.
Judge, I spoke Mr. Bullock. I spoke Mr. Bullock. My understanding is that this isn't recent. He hasn't seen the alleged victim since. My understanding is the alleged victim is the one that initiated by attacking Mr. Bullock with the broom. Having said that, Judge, he just got a job approximately 3 months ago. He's a truck driver and travels within the Tri-County area. Now, he's been residing here in South Florida for the past 13 years. He's going to try and have his friends and family to help post his monetary bond, Judge. We were going to be requesting that the court consider setting a $5,000 bond on Mr. Bullock's behalf, Judge.
All right,
Your
thank you.
Honor.
Not only was the alleged victim's orbital bone broken, but as well as his nasal bone, so they cool off frontal facial area. It's also alleged in the police reports that this was captured on video recording, which coincides with the victim's depiction of the allegations that he was attacked by the alleged defendant and that there was no initial attack by the victim. So based on all of that, the strength of the evidence against him, I am going to set bond in the amount of $15,000. The conditions of your bond, sir, even while you are in custody, you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Yes, ma'am. Can I say something, ma'am, Your Honor?
Don't talk about the facts of your case, Mr. Bullock. Everything you're saying is being recorded and can and will be used against you. Do you understand?
I do, ma'am.
Are you sure there is something you wanted to say?
Ma'am, I'm telling you that this, I don't know what recordings they have, but this guy literally hit me with the broom, Your Honor, and I was defending myself. I have no reason to attack this man. I did not know him. I'm telling you, Your Honor, this is not the truth. What you have in front of you, this man attacked me, Your Honor. I have no reason to attack this guy. I defended myself. The fact that I was able to defend myself against his attacks makes me look bad, Your Honor. But I'm telling you, this guy hit me with the broom.
All right, Mr. Bullock, I also see in the reports that further investigation revealed you were identified and suspected in assaulting the female friend who on multiple domestic violence incidents. So not only was there this listed victim whose face you allegedly broke with your fists, there was also the female that was present that you were alleged of being the suspect of multiple domestic violence incidents. So this, yes, Mr. Linder?
Your Honor, I also want to advise the court, I didn't see this looking the first time through. I'm showing that Mr. Bullock has a history of batteries. 2020 battery, 2020 violation of a domestic violence injunction, 2019 battery, another battery in 2019, and another battery in 2019. There is a woman that whose initials are BW that has a non-expiring injunction against Mr. Bullock from May of last year. And I am also showing, a moment, Your Honor. He does have a domestic violence related arrests, Your Honor, out of the state of Ohio, but they are dated going back to the 90s. Nothing further.
All right, thank you. Based on that new information, once you post bond, you're going to be supervised by pretrial release level 2 with the GPS. There's an escalation of violence with 3 convictions for battery in 2019, another in 2020, and a violation of domestic violence injunction in 2020 as well. You cannot have any contact, direct or indirect, with the listed victim. Do you understand?
I do understand that, Your Honor.
Okay, that means no phone calls, no going where the listed victim lives, works, if he's still in the hospital, no having a family member or friend send a message to him, or any other means of communication I have not said. Understood?
Your Honor, I understand that, but Your Honor, I think that it is completely unfair that I'm being charged $15,000 when I'm supposed to be innocent until proven guilty. I haven't even had a chance to tell my side of the story. I didn't even know that this was a case until yesterday, Your Honor. And the only reason I know about the case, Your Honor, is because I know that that's the guy that got in a fight with. The reality is, Your Honor, me and the guy got into a situation and I won the fight, Your Honor. That's exactly what happened. The guy attacked me. I did not attack this guy. And I just think.
What case is he currently on probation on? It says right here he was taken into custody at probation office.
I was speaking with Mr. I brought that up to Mr. Ndachi. We were trying to figure out, like, I don't see that he's on probation on anything. I don't know why he was at the probation office.
Judge, my understanding is, being Mr. Bullock, he is on probation. Basically, he was placed on probation after this alleged incident took place. He's been reporting. My understanding, Judge, probation, there's been no incidents. He's been under supervision, been reporting as required. They are aware of his job. They are allowing him to work as a truck driver and work within the Tri-County area. He was reporting, and that's where he was staying into custody. Judge, we're going to be asking at this time for the court, considering he's already being supervised, if there is going to be any allegations of violations, there are procedures in place. There'd be a warrant prepared on his behalf, and he would be remanded into custody. So, Judge, I'm going to ask the court to reconsider and not impose the level 2, considering he is working. And if the court did want to go ahead and add a double layer supervision, then would the court consider standard pretrial as opposed to level 2?
Please, Your Honor.
Sir, you also cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Ma'am, I do.
Yes, Mr. Linder?
Yes, it would appear he was placed on probation by Judge Solomon May 5th of this year, but just noting in response to Mr. Romero's request, the point of these conditions is to deter and prevent things from happening, not to have something in place should he violate court orders, which is basically the argument for probation, that if he does something, well, then there's some mechanism in place to take him in custody.
All right, thank you.
Your Honor, I'm doing very well for myself.
I'll file a motion with your division, Judge. Good luck to you. I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, Mr. Bullock. Once COVID is over, you'll need to reapply. Next is Mr. Scalmato on page 20, who's refused. We're proceeding without him. I do find probable cause for possession of fentanyl and a pretrial warrant for possession of fentanyl that he's being held no bond on. I will leave the bond in place based on the same offense that he's currently being held no bond on, being a PC case today, and I will provisionally appoint the Office of the Public Defender to represent him during the pandemic. Anything else on Mr. Scalmato?
No, Judge. We have Mr. Hardin back.
Okay, so let's recall Mr. Hardin. I believe he was on page 19, correct?
Yes.
Okay, thank you. Mr. Hardin, good morning, sir. I find probable cause for trafficking in methamphetamine, 14 grams to less than 28 grams. Possession with intent to sell or deliver. I believe it should be fentanyl, correct, Mr. Linder and Mr. Farber?
Correct.
Okay, count 3, possession with intent to sell or deliver cannabis. And count 4, what's the trafficking amount for alprazolam, Mr. Linder? I'm assuming.
There isn't I don't believe there is trafficking in alprazolam.
Okay, so that must be why. So count 4, possession of alprazolam or Xanax. There's no with intent to sell or deliver either, based on that amount.
Your Honor, at this point, I'm just deferring to the arresting officer, considering the significant bond attached to the trafficking count.
All right, so I'll just find PC for as presented on count 4, possession of alprazolam, count 5, possession of drug paraphernalia. Mr. Linder, first to you.
Your Honor, well, I see no history, and certainly I can understand the court taking that into consideration for a mitigating factor. When setting bond, I would just ask that the court take into consideration on count 1, that even with no priors, if he is convicted of that offense, he faces a 3-year minimum mandatory prison sentence. Nothing further at this time, Judge.
Okay, thank you. Mr. Romero?
Mr. Hardin has been residing in our community for almost 5 years now. He is employed. He works at a place called Mini PETA. Been there for 2 years, making approximately $12 an hour. He lives in Oakland Park with his father. My understanding, his father does know he's incarcerated, will be helping post his bond, but his father is retired and receives Social Security, so not going to be able to afford to post the $50,000 bond attached to count 1. We were going to be asking for the court to consider bond reduction to $7,500 on count 1, and we were going to be asking the court to ROR count 5 and to provisionally appoint our office.
All right, I'll ROR count 5, but the only way I would consider a reduction, Mr. Romero, is if he's on a GPS monitor.
Judge, no objection.
All right, I'm not going to reduce it to the amount that you requested, but I am going to reduce it significantly. Count 1, I'll reduce to $20,000, leave the other bonds in place. Once he posts bond, he's going to be on pretrial release level 2 with a GPS, so he can still work, but with a pre-approved schedule. Does your office need to be provisionally appointed?
Yes, Judge.
All right, I will provisionally appoint the Office of the Public Defender to represent you during the pandemic. Once COVID is over, sir, you will need to reapply to make sure they keep representing you. Good luck to you, sir. All right, so back to page 20, Mr. Stokes.
He's approaching.
All right, thank you, Mr. Stokes. Good morning. I do find probable cause, grand theft of a firearm, possession with intent to sell or deliver cannabis. Count 3, possession of cannabis over 20 grams. Count 4, carrying a concealed firearm. 5 is a capias on a resisting without violence. Mr. Linder, first to you.
Your Honor, I'm recommending an ROR in count 3, asking that the court keep the other remaining bonds in place, just noting the amount of cannabis that was located and just the firearm, the nature of the firearm offenses. I'm just checking to see if there's any history. Judge, I'm showing an open burglary, conveyance, and grand theft auto out of Palm Beach County from this year. An open resisting without violence out of Palm Beach County from this year. Obviously, the open resisting without violence out of Broward that he failed to appear in court on. And nothing further, Judge.
Thank you, Mr. Romero.
Judge, I believe the state is, their recommendation was leave the bonds in place except for count 3 and ROR. Considering what we were advised of, that is reasonable. At this time, we're going to be asking to be provisionally appointed.
All right, thank you. So I will leave the bonds in place on 1, 2, 4, and 5, and ROR on count 3. Sir, you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
Yes, ma'am.
And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, Mr. Stokes, you will need to reapply to make sure that they keep representing you. Anything else on his case that we need to address?
No, Judge.
Good luck to you, Mr. Stokes. Next is Mr. Rodriguez on page 20, who's waived his presence. I do find probable cause for his probation violation regarding lewd and lascivious molestation on a child 12 to 15. He's being held no bond. He's going to have to go before his division judge to answer to this these allegations. Do we have a date yet for Mr. Rodriguez's division judge? It's division FH. Would it be tomorrow for a first VOP? Okay, so he is going to be seen by his division judge. Let me write it on here. First VOP, Division FH on 7/15/2021. At what time? 8:30? At 8:30. Okay, he's going to be seen at 8:30 a.m. Does your office need to be provisionally appointed?
Yes, Judge.
I will provisionally appoint the Office of the Public Defender to represent him during the pandemic. Anything else, Mr. Rodriguez's case?
No, Judge.
All right, thank you. Next on page 21 is Mr. Watkins.
You see her present right next to me, Judge?
All right, thank you. Mr. Watkins, good morning, sir. I do find probable cause. You have 2 signed warrants on counts 1 and 2, violation of community control. You're being held no bond on. Count 3 is a signed warrant regarding carjacking with a firearm or weapon. I also make a finding of proof evident presumption. Great. I am going to hold you no bond on that. Count 4 is I do find probable cause for battery on a person 65 years or older. Counts 5 and 6 are court orders holding you no bond on those same offenses. So he needs to be held no bond on the battery on a person over 65 as one of them.
Yes, Your Honor. I think that would ultimately is up to Judge Casey to decide what he's going to do in that. It's really not going to prejudice Mr. Watkins because you already did find proof evident presumption great and no bond on the carjacking, and he is still serving a Florida State prison sentence, Your Honor.
Okay, thank you. Mr. Romero, he's being held no bond on 1 through 6.
One moment, Judge.
What's he in prison for?
Ms. Cooper, do you have that by any chance?
Judge, at this time, we're going to be asking to be provisionally appointed.
All right, thank you.
And Judge, just for clarification, I know on the BOPs, I believe now they are seeing their judge within the 24 hours. Is that correct?
Yeah, he should be before Judge Casey tomorrow. It's division Actually, it's Judge Fine, he's on violation of community control.
I think that might be, I think Judge Casey took over Judge Fine's division. It just says Judge Fine because that's who is the judge of the division when he was put on probation. I think possibly.
Well, which division is this? Because I need to write it on here. Is it FY? It says FY.
I'll check again, Your Honor.
The warrant says FY. That is the Rockport division. So he's going to be transferred to the career criminal unit. All of these charges will be before Judge Fine in the career criminal unit. It looks like you will have a first VOP tomorrow, division FY. Again, the career criminal unit, you're going to be seen tomorrow, the 7:15 at 8, sorry. Which case?
That's on the card. That's on
I
the.
have a 2019 case, ma'am.
The 1993-812, and I'm looking up the other thing.
It's a division FY case, ma'am. It's a Rockport case. It's a career criminal case. It's not Judge Casey. He's not the career criminal judge. No, ma'am. He's going to be before Judge Fine tomorrow in division FY because that's who signed the warrant. It's the warrant says division FY. It's a career criminal case. He needs to see the career criminal judge. There's no order that should have transferred that case out. It's a lower case number. If anything, it would be the opposite. The new case needs to go to career criminal. So, sir, we'll see Judge Fine tomorrow at 8:30 a.m. on the 15th with regards to the first VOP, or actually violation of community control. And you are ordered to, even while you're in custody, not have any contact, direct or indirect, with the listed victim. Do you understand? That means even while you're in custody, you cannot call, send letters, have a family member or friend send a message, or any other means of communications. Understood?
No.
You also cannot possess any firearms, weapons, or ammunition while your case is pending. Understood?
No.
And if your division judge does release you from custody, you cannot return to the incident location. Understood?
Yes, ma'am.
And I will provisionally appoint the Office of the Public Defender to represent you on both of these cases during the pandemic, sir. Once COVID is over, you will need to reapply to make sure that they keep representing you. So that needs to be, I don't know why this would be transferred out, but yeah. All right, good luck to you, sir.
Judge, I know you asked. Did you still want to know what his prison charges?
I saw there was burglary.
Yeah, it's burglary, fleeing, eluding, grand theft.
Okay, thank you. Next is Mr. Zerlino on page 22.
He's here, President Judge, I may.
All right, thank you. Good morning. I do find probable cause for possession of methamphetamine and drug paraphernalia. Mr. Linder. Oh, sorry, Ms. Worrell. Sorry about that. I wasn't looking.
Pretrial is requesting a revocation and also conviction for this defendant who was released out on pretrial in case number 216316 CFNA. One count of possession of methamphetamine on the 4th of July.
July 4th. Okay, thank you. Mr. Romero, I'm not sure if you heard, pretrial requested a revocation. He was released to pretrial on July 4th, 2021 for another possession of methamphetamine. So Mr. Linder, first to you.
Just recommending that the court revoke his pretrial, set the $1,000 bond back on that possession of methamphetamine, and keep the $1,000 bond on this one as well.
Okay, thank you. Mr. Romero.
No objection, Judge. We're just going to be asking for a property order.
Okay, does your office need to be appointed?
Then a public defender, Judge.
Okay, so I will grant pretrial's request, revoke and set that bond at $1,000, leave the $1,000 bond in place, sign a property order, and provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Good luck to you, Mr. Zerlino. Next is Mr. Brown on page 22, who's waived his presence. I do find probable cause for his 3 violations of probation or community control for burglaries, trafficking or dealing in stolen property, false info on pawn items, and another burglary. It looks like guns and drugs were allegedly found during an administrative search, so he is going to be held no bond. He will have to see Judge Merrigan tomorrow. What division is that? I need the division letters, please, so I can set it on the.
I think it's FE, but I'm not.
FE? Thank you. Okay, so his first VOP will be tomorrow Division FE 7/15/2021 at 8:30 a.m. before Judge Merrigan. And I will provisionally appoint the Office of the Public Defender to represent him during the pandemic. Anything else? Okay, thank you. So that brings us to page 23. Mr. Bogman is a delete because it was set in error. Next is Mr. Clark on page 23.
Here, present Judge in Maine.
All right, thank you. Good morning, sir. I do find probable cause for battery on an officer, although you were only charged with one. There are allegations that there were two officers who were allegedly struck, kicked, or gun belt grabbed. Count 2, drug paraphernalia. Count 3, resisting with violence. Count 4, corruption by threat, public servant or family. Count 5, traffic infraction. Mr. Linder, first to you.
Your Honor, I'm showing priors for 2018 battery on a law enforcement officer and resisting with violence, 2018 resisting without violence and threat to specified individuals, 2018 battery, 2015 possession of cocaine, 2015 possession of cocaine, 2014 possession of methamphetamine, 2014 possession of cocaine resisting with violence, 09 possession of methamphetamine, 02 resisting without violence. Judge, based on the allegations, I'm recommending a $2,000 bond. I'm sorry, a $1,500 bond on 1, $500 bond on 3, a $1,500 bond on count 4, and an ROR on count 2.
Thank you, Mr. Romero.
Judge, I spoke to Mr. Clark. I'm assuming what's also written in the police report is that Mr. Clark sustained a number of injuries to several officers that were involved in this incident. Having said that, Judge, he's not working. He's looking for work. He lives in Fort Lauderdale with his aunt. His family's going to try and get the funds together to post his monetary bond. We were going to be requesting the court consider a $500 bond on count 1. No objection to the ROR on count 2. No objection to the $500 bond on count 3. We were going to be requesting on count 4 a $1,000 bond, and we're going to be asking to be provisionally appointed on his case.
All right, thank you. As for the reasons I already said on the record, with regards to him allegedly reaching for the officer's gun belt, I am going to set bond on count 1 at $2,000. Also, there being 2 officers that he allegedly attacked, not just one. On count 3, I will set bond in the amount of $500. Leave the bond actually on count 2 ROR. It's a drug paraphernalia. Count 4, I will set bond in the amount of $1,500. And I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you'll need to reapply to make sure that they keep representing you. You're also going to be supervised by pretrial release. So once you post bond, you have to call in the next business day before 11 a.m. because the drug influence box is checked off. So that means that you cannot use drugs and you cannot use alcohol while your case is pending. Do you understand?
Yes.
All right, you're going to be randomly screened at least 1 time per week based on these allegations. Do you understand?
Yes.
All right, anything else in Mr. Clark's case we need to address?
Yes, what's the bond?
Count 3 is $500.
The number you have to call the next day.
All right, good luck to you, sir.
Yeah.
All right, next is Mr. Duravne on page 24.
Mr. Duravine, come on up, sir. I know, I'll call.
All right, good morning, sir. I do find probable cause. Count 1, aggravated assault with deadly weapon without intent to kill. Count 2, Mr. Linder, the amount says it's $250. What the officer claimed, the $750 in business loss as part of the criminal mischief. Do you have an objection to reduction to a misdemeanor over 200? No?
No, Judge.
Okay, thank you, Mr. Forbear. Defense was to be heard. All right, thank you. So it's criminal mischief over $200. But less than $1,000 on count 2. Count 3 is missile into dwelling or a building. Count 4, resisting without violence. Mr. Linder, first to you.
Judge, I'm recommending a $5,000 bond on counts 1 and 3, $100 bond on 2. No victim contact, no return, no possession of any weapons. As history, I see a 2000 out of Broward 2013 possession of cocaine with intent to sell or distribute. Resisting without violence, moment, Judge. Trespass 08. And he was arrested June 26th of this year under the name John Dodge for trespass, resisting without violence. The bond on his trespass was raised to $500. They also have him out of county hold for possession of marijuana out of Lee County. He's out on a total bond of $1,600. Nothing further.
Okay, thank you, Mr. Romero.
Judge, he's been residing in South Florida almost his whole entire life. He works in construction. He lives in Hollywood with his aunt. My understanding, he's going to try and contact his mother to help post his monetary bond. She's a caretaker. What we were going to be requesting is on count 1, a $2,500 bond. On count 3, a $2,500 bond. We were going to be asking for the misdemeanor offenses if the court would consider an RR on those 2 counts. And we're going to be asking to be provisionally appointed on his case.
All right, thank you. Mr. Linder, what was the state's request on 3? Sorry.
No, it's okay. 5,000 on both the ag assault and the missile to dwelling or building.
All right, thank you. So on count 1 and 3, I will set at $5,000. On counts 2 and 4, the misdemeanors, I will ROR. Sir, the conditions of your bond, even while you're in custody, you cannot have any contact, direct or indirect, with the listed victim. Do you understand?
Yes, Your Honor.
All right, and that means that you cannot call, send letters, have a family member or friend send a message to the listed victim, or any other means of communications that I have not said. Do you understand?
Your Honor, can I ask you one quick question, Your Honor?
Okay, but before you do, sir, I do have to advise you, you have a constitutional right to remain silent. Everything you're saying is being recorded and can and will be used against you, so do not talk about the facts of your case, okay?
Understood, Your Honor. Your Honor, I just want to ask will the court please consider the aggravated at least pre-trial release with supervision, Your Honor. I can't really, I do work, but it's kind of steep, and I really be thankful if the court would consider pre-trial release on the last call.
All right, Mr. Darabont, I understand your request. However, the allegations are that you threw a 5-foot metal pole through the business drive-through window because they would not serve you on foot. So I have to take that into consideration when considering the safety of the community. And based on the randomness of this act of violence, I've already set the bond, so you'll need to file a motion with your division judge, okay? All right, so I will also order, in addition to no victim contact, no return to this victim business, and no possession of firearms, weapons, or ammunition while your case is pending. I will provisionally appoint the Office of the Public Defender to represent you during the pandemic, sir. Once COVID is over, you will need to reapply to make sure they keep representing you. Good luck to you, sir. Your attorney can always file a motion with your division judge. All right, so is that it on his case? All right, next is Mr. Amick on page 25, who is a second refusal, so we're proceeding without him. I do find probable cause for possession of heroin and possession of drug paraphernalia. I will leave the bonds in place based on his refusal to come to court, and I will provisionally appoint the Public Defender's Office to represent him. Anything else on Mr. Amick? All right, thank you. That brings us to, oh, that didn't slide. All right, that brings us to Mr. Amy on page 25. All right, sir, sorry if I butchered your name. Is that how you say it?
Yes, I'm going up.
All right, thank you. I do find probable cause for aggravated battery with a deadly weapon. Give me 1 minute to pull up police reports. Yes, Mr. Linder.
And Your Honor, I see that there's a $5,000 bond that's put in the KPS. I'm reaching out. I'm actually on the phone right now with the assigned ASA, just checking to see if that's the bond that Judge McCarthy set, because I do see, like another case we had with her recently, there's an order taking him into custody.
Okay, thank you. I saw that handwritten order as well. While we're waiting on that, I am ordering that you cannot have any contact with the listed victim, direct or indirect, sir. Do you understand?
Yes, Your Honor.
All right, that means that not only can you not go by where they're living, working, if they go to school, you cannot call, text, email, social media, send letters, have a family member or friend send a message to the listed victim, or any other means of communication that I have not said. Understand?
Yes, Your Honor.
You also cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand?
I never did. Yes, Your Honor.
Okay. Okay, just give me 1 minute. We're just looking into something to see if this is something that Judge McCarthy said or if this is something that I need to set. Okay, just give us 1 minute. While they're looking, Mr. Romero, it looks like your office has already filed a notice of assignment, so you do not need me to provisionally appoint then, correct?
That is correct, Judge.
Okay, thank you.
Your Honor, what I can tell the court,
Yes.
Judge McCarthy kept the $5,000 bond that's on the capias. Where you see it's, if you look at the 1024, the 814 capias, where no bonds crossed out and $5,000 is put there. What nobody's able to answer is who put the 5,000 there though, but it is, but at this point, it is what Judge McCarthy issued going based on that capias. That's, yeah, I don't know.
Well, I have her number. Give me 1 minute. Let me call her. All right, so I just got off the phone with Judge McCarthy. Whenever you're back, Mr. Romero. She is not, I see you there, thank you. She's not entirely sure how that $5,000 bond got there, but she's not the one that set it there, so he needs to be, come through magistrate. So, but when they realized that he was never served with that capias, for some reason that had $5,000 that mysteriously got on there, he was remanded into custody yesterday. So the original magistrate on the Agasol, it was $1,000 plus standard pretrial release. So with regards to the ad charge on the state's information that added the aggravated battery, Mr. Linder, I'll first go to you, then.
One moment, Your Honor.
She's saying Judge McCarthy didn't address the sales survey. Right now. Unusual. I thought she would have remanded. I just don't know. Doesn't make sense, but. Was in your store. We're gonna find it.
Thank you, Judge. Your Honor, while I see no history, I would note the allegations are, while the initial probable cause affidavit just alleged that he attempted to strike the victim, based on further investigation, Your Honor, it's been revealed that according to the allegations that Mr. Emmy did in fact additionally strike the victim with his vehicle, forming the basis for the aggravated battery charge. Based on that, Your Honor, while I see no history, that is a second-degree felony as opposed to just a third-degree felony on the ag assault. I'd be recommending a $7,500 bond, no victim contact, no possession of any weapons, firearms, or ammunition. Nothing further.
Okay, thank you, Mr. Romero.
Judge, as you heard, Mr. Imee has basically a clean record. My understanding is he's been going to court for quite a while. He has an assigned public defender, as evidenced by him as recently as yesterday, showing up to court. He's not a flight risk. He's going to be addressing these allegations. Right now, he's not working. He's looking for employment. He's been residing here in South Florida for 20 years. Judge, we were going to be asking the court to consider somewhere around the $2,500 bond with supervision, Judge.
All right, thanks. So I am considering both parties' arguments. Really am not sure how this got here, but I will leave $5,000. But once he posts bond, he's going to be supervised by pretrial release like he is for the other count. He's already supervised by pretrial release with the aggravated assault. He's going to continue to be supervised by pretrial release, but for this count as well, the aggravated battery. I've already advised you, sir, you cannot have any contact with the victim, direct or indirect, and you cannot possess any firearms, weapons, or ammunition while your case is pending. Do you understand the orders that I previously advised you of?
Yes, Your Honor.
All right, sir, you also, it looks like you're before Judge McCarthy and you already have assigned public defender. Anything else on his case we need to address?
No, Judge.
All right, good luck to you, sir. All right, is Mr. Mustafa back yet on page 15?
No, Judge, he's still in court.
Okay, so let's do the last two 30/40s and then and the quarantine, and we'll see if he comes back.
Yes, Judge.
Okay, so who do we have first?
Mr. Andrew Philip Pennant. He is on your second look docket, Judge.
Okay, so this is a second look. All right, sir, good morning. Second look on a grand theft auto. Mr. Linder, first to you.
Your Honor, I'm asking that the court keep the $1,000 bond in place. Mr. Pennant has a pending trespass from June of this year. He also has a pending burglary of a dwelling and criminal mischief from 2019.
Okay, thank you. Mr. Romero.
Mr. Pennant advised me at this time for money. He works at a labor pool, but his intention is to, I believe, become a paramedic.
I'm a paramedic.
He's homeless at this time, and nobody can afford to post his bond as evidence of him still remaining in custody. He's asking to be released on pretrial release.
All right, I understand his request. However, he does have a pending burglary of a dwelling into someone's home. I'm going to take no action at this time. He'll have to file a motion with his division judge. Just be advised, Mr. Pennant, even though I'm not doing it, your division judge may revoke your bond if the state files a motion. Good luck to you, sir. So at the last case, there should be a Mr. Alstonot, correct? Oh, he bonded? Okay, did he bond, Ms. Cooper? Okay, thank you. So Mr. Alstonot has bonded, so could you please do an order deleting him because he bonded? Okay, so that would leave us with Mr. Bailey and Conti.
Alstonot was on the 30-day. He was in the front.
Is Conti there? Do you guys have Mr. Bailey on the second look? Can you guys call Conti, please? They only have one person left. It was a gentleman in quarantine. You guys want to reset Mr. Mustafa till tomorrow then on page 15 since he's in court, or do you want to waive his presence?
Judge. I'll waive his presence unless, does he have a private attorney? That's the only reason why I won. Because I know he's being held no bond on 215680 CF10A.
I'm gonna look at this. Let me see who's representing him. There's nobody representing him. There's no notice of appearance.
In that case, Judge, I'll waive his appearance.
All right, thank you. So we'll go forward in absentia without Mr. Mustafa. I do find probable cause, petty theft, second degree, third or subsequent offense, operating without a valid driver's license, grand theft, petty theft, second degree, third or subsequent offense, grand theft, $5,000 or more, but less than $10,000. Petty theft, second degree, third or subsequent offense, and 2 cases that he's being held no bond on 7 and 8, and count 9, petty theft, second degree, third or subsequent offense. I will leave the bonds in place with an order of no return to any of the incident locations and no driving without a valid driver's license. And I will provisionally appoint the Office of the Public Defender to represent him during the pandemic. Anything else in Mr. Mustafa's case?
No, Judge.
All right, thank you. The last person we have is Mr. Bailey at Conti facility. Mr.
I called Judge.
Okay, thank you. Do you have an offer even on that case? Okay, I was just making sure. Yes, ma'am. Yes, ma'am, I'll do that while we're waiting. Oh, look, there he is.
This is Dana. I'm gonna be going to the unit. It should take me a couple of minutes. I'll be there shortly
Okay, thank you.
to get Bailey because he's in quarantine. I cannot bring him down here.
Okay, thank you. All right, so we'll be in a brief recess. Just let us know when you guys are there.
We're ready, Your Honor.
Okay, thank you. Okay, so this is on the second look docket. Mr. Is it Bally, sir?
Yes, Bailey.
All right, Bailey, sorry about that. Mr. Linder, does the state have an offer for him?
Yes, Your Honor, just to advise the court, Mr. Bailey was being held on a felony VOP. That's why his bond was kept in place. He has resolved that. He has completed his sentence. If he wishes to resolve this trespass, the offer would be an adjudication, time served, no return to the 7-Eleven at 1500 South Cypress Road in Pompano Beach.
Thank you, Mr. Farber.
Judge, I didn't have an opportunity to speak to him, but Mr. Bailey, are you trying to resolve this case today?
Mr. Bailey, do you wish to accept the state's offer, or do you need more time to talk to your attorney?
Yes, I am.
Yes, to which one, sir? It was a two-part question. Mr.
No,
Bailey.
I'll accept the offer.
Okay. All right, so Mr. Bailey, please raise your right hand for me, sir. Mr. Bailey, can you hear me? Do you swear or affirm to testify to the truth, the whole truth, and nothing but the truth, sir?
Yes, sort of.
What do you mean, sort of? It's a yes or no question.
Yes, I do.
All right, sir, you can put your hand down. Please state your name for the record.
I'm listening to you because it's garbled.
I think it might be, it looks like they have some connectivity issues. I was just making sure. All right, so please state your name for the record. We're trying to get a better signal. All right, Mr. Bailey, let's see if this helps. Thank you, Deputy. Mr. Bailey, please state your name for the record.
State your name for the record. Oh, John Bailey.
All right, Mr. Bailey, is it my understanding you wish to resolve your trespass case, correct?
That's correct.
Do you understand the charge against you?
Yes, I do.
Do you understand everything that's happened here today?
Yes, I do.
Is anyone forcing you to resolve this case? Sorry, couldn't hear you.
No, nobody's forcing me to resolve this.
Okay, are you under the influence of alcohol or drugs, sir?
No, I'm not.
You need more time to speak with your attorney, Mr. Farber.
No, I don't.
Okay, have you ever been treated for mental or emotional illness? Okay, is there anything about the illness today that impacts your ability to accept this plea?
Nothing.
Is that a no? All right, and Mr. Bailey, do you understand you have a right to go to trial, but you're forever giving that up by accepting the state's plea offer?
Yes, I understand that.
All right, and I'm not asking if you're a citizen. I just have to advise everybody that takes a plea before me. Do you understand if you're not a United States citizen, that taking a plea today shall subject you to deportation proceedings, sir?
Yes, I understand.
And how do you wish to plea, Mr. Bailey? Guilty or no contest?
No.
Sorry, what was that?
No.
All right, sir, thank you. I do accept your no contest plea is freely, voluntarily, knowingly given. I also find there is a factual basis for this plea, and I will sentence you to an adjudication, time served, no return. Are you asking for a civil lien? All right, now I'll convert to a civil lien because he was sentenced on his violation of his felony VOP. Good luck to you, sir. What that means is that it's a civil judgment that's good against you for 20 years. If you ever do come into the money, you'd have to pay that off, Mr. Bailey. Good luck to you, sir.
Thank you.
All right, no problem. Do we have any other questions, guys? I believe that's it for the docket. All right, everybody go have a good afternoon. It's my understanding the system is back up, so we'll be on the actual first appearance system tomorrow. If If you could just please let Mr. Romero know if he does have any quarantine cases, to let Mr. Edwards and our video operations know so that they can set up the system for us, the Zoom system. Otherwise, we'll just be on this regular in-court system tomorrow. Everybody have a good afternoon and a good night. Thank you. See you on the regular system.
Okay, ma'am.
Thank you.
Sorry.
Deputy, if first appearance is over, I'm going to end it now.